She walks in loud like a thunderstorm, debunking myths with style and form. True crime conspiracies her game. Alyssa Jade, remember her name. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Alyssa Jade, she's got no shame. Microphone fierce like a roaring lion, unveiling secrets people been hiding. True crime queen of the digital scene, Melissa's got you hooked on her screen. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa J, she's got no shame. Murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa J, she's got no shame. Melissa J, she's got no shame. Melissa J, she's got no shame. From murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa J, she's got no shame. 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 She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa J, she's got no shame.
Hello, everybody. Woo, perfect. Hello, Shabanae.
Hey, girl.
Hi, ATS. Hi, Shar. Hi, Cat111, Michelle, Corso, Curious Christine. I feel like I just said ATS, but I don't remember now if I said ATS. ATS. Okay. If I didn't, hi, Harlot, Renee, J13, Gidget. We have Jofo, Abby, Amanda, Poor Linda, Stacy Cole, the Widu Sama. Let me see, Marie Joey, Jess G, Name Change, Fall 12. Yeah, I just posted on Patreon the Epstein Vault and stuff, and we're gonna see more was supposed to be released today. I know Tess is keeping up with it too. And I guess we'll see, but yeah, there's already been talk about it. Some stuff being deleted. It's not like I expected to get everything. I just really don't expect that ever. Hi, Stephanie. Hi, Sprinkled Dog Nut. But I look forward to at least what we get to see.
Oh, yeah. I watched Tim Cast earlier. I saw he covered a little bit. I'm like, oh, I want to see it.
Hi, Shite Show Supervisor. Hi, Karen. So welcome. I'm so happy that we were able to do tonight because I feel so bad for last night. I'm truly sorry, guys. Hi, Moonchild. I hate when I'm not in it, and it's so unexpected, but I unplugged as soon as I got off. I sat in darkness. That's kind of what you have to do because everything is just but it's better today. Sore, but it's better today, thank goodness. Hi, our Bubbles, and I'm just so excited to get back in and read this final witness and go into the Frank's motion and the lemonades that are coming. Now we have a little bit of a possible idea of what all of this medical talk is about, but we'll get into that in a minute. I want to start things off by saying our missing child from last night's stream has been found safely, and so thank goodness. But we do have another active Amber Alert that is on the NCMEC site, and so this is Gaidy or Gaidy, I'm not sure how it's pronounced.
Gaidy.
Hernandez, which, what a name, right? Hernandez. Missing since February 21st, 2025 out of, well, it says Siler City, but I thought it was Silver. Okay. Siler City, North Carolina. She is 15 years old, female, Hispanic, brown hair, brown eyes, 5'3", 120 pounds. She was last seen wearing jeans, shorts, and a red shirt with a bear on it. Has a Jordan Matthews high school laptop with her. Okay, so this is absolutely beautiful. Absolutely beautiful.
Oh, yeah, she is.
Mm-hmm. And it says the updated clothing description, and she may be with two individuals. The Siler City Police Department is requesting your assistance with locating a missing juvenile. Jaidi Liseth Fernandez is a 15-year-old Hispanic female, approximately 5'3" tall, weighing 120 pounds. She has brown hair, brown eyes, jean shorts, and red shirt with a bear on it, and has a Jordan Matthews high school laptop with her. So if you or anyone who knows information on her whereabouts, please don't hesitate. Contact 911 or the Siler City Police Department at 919-742-5626. And you would think that they'd have like some tracker on those damn school laptops, right? But I guess they don't.
I mean, they have to be Wi-Fi connected, so I don't know unless they allow. Yeah, I don't know.
Happy birthday, Jessica. Enjoy dinner.
Happy birthday, everybody.
My jaw popping off a horrible pain. Please get it checked out, Kimmy, because that's also what happens with the TMJ. Sometimes, like, if you try to open your mouth, like your jaw can like pop in and out and it clicks. Like my jaw always clicks obnoxiously to where, like, if I'm eating, not always, but like sometimes something more like chewy, you hear the click, 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 click. At least I could hear it, like, and I could feel it. And it's, yeah. Hi, C. Carter. Yes, prayers that she is found safe. Absolutely, Amanda. Absolutely, prayers and positive vibes for you and your family. I'm not sure what's going on. You don't have to share, but absolutely, if you pray, send out positive vibes, manifest good things for you and your family. Hi, crime all the time. Have trackers, Katie? Yeah. Oh, that's so funny, Jessica. When I eat steak, yep, definitely get it checked out. Hey, Wolfie, number 4. Thank you for showing a new missing person every live. Yeah, absolutely. Okay, so I'm so excited. Because I just kind of want to jump right into this, but I want to just for a second, jump a little bit ahead. We're not up to it yet, but you want to explain what's on the docket and what you can see with the limine?
Oh, yeah, sure. So it's in the case summary. Hold on. I'll grab that. I want to read it right. Hold on, I'll get the picture. Okay, so go ahead.
No, you're good.
I'll say, so whenever you go to the Idaho cases of interest, like within their website, there's a case summary at the top, and there below is like links to all of the documents that they have uploaded. So a lot of people like to look at the case summary because it will be updated before documents actually load, but it'll also state on there what's been submitted in the record that is sealed too. So we noticed that on February 24th, there was a motion to redact or seal newly filed records, a stipulated motion to file defendants' exhibits in support of their motion to strike the death penalty regarding autism spectrum disorder under seal. So where it will be redacted. So it sounds like that they have done some evaluation, like heavy evaluations throughout Bryan's time and being incarcerated and awaiting trial. So that is interesting. That could be why they were asking the questions about what we could see in the medical side of things, maybe a different chromosome. But that was interesting.
It's very interesting. And happy birthday, hippie chick. Hey, Penelope. So I'm very curious to know if there are, I'm curious to know a few things. If there are already existing documentation to show that Bryan is on the spectrum, or if this was an evaluation done since he's been incarcerated. And number two, is this what they're talking about in regards to medical diagnoses regarding the DNA? But I cannot imagine that, because it wouldn't be in it, I mean, unless I'm understanding it wrong, would that be able to be determined in your DNA? I don't believe so. No. Are you sure? Because then we wouldn't have to have those types of evaluations. We would be taking it blood draws and diagnosing.
I mean, that's a great question. I mean, I think there's a lot to it, but I think what's most interesting about this, though, is that it's more in reference to being able to strike the death penalty. And it's a question of, are there people with autism that have committed crimes? Yes, but there's a Supreme Court ruling in that that goes with it. So this would be like very precedent if this isn't how they would evaluate it. I don't know. Do you want to play the clip that we had from the Arizona one? I think that best explains it, so I don't like trip on anything. It's up to you, though. If people are wondering like why this is a thing and it is being talked about and awaiting is just some legal matters that may come with that.
Yeah, I'm more focused on
In the headlines.
I'm more focused on it being related to the medical, but again, as far as I understand, it's not in your DNA, it's not in your blood, it's not anything that they can, hey, well, we do know based on DNA left behind, the killer is on the spectrum. You know what I mean? So I think that this is just completely separate from the medical that we're seeing being questioned about in the DNA. Hi, Texas girl.
Yes, genetic testing can identify markers for autism.
I don't know what they can get from, let's say, IgG. And it's not as simple as that. Or again, they
Yes.
would be diagnosed like that. If when we go and get like our children or adults evaluated, they would be pulling from physical tests, not diagnosing on a mental evaluation.
I understand. So according to UCLA Medical School in April 2024, a majority, around 80% of autism cases can be linked to inherited genetic mutations and will show up as markers in your DNA.
But that's do they do any tests, physical tests, to determine and diagnose autism?
They are able to see that now, but there's still, I think the mental one is different, because that's going to be assessing, because the spectrum is so wide and vast in that, like where that person may lie in that spectrum. That's the way I would approach it, beyond just looking at a DNA marker. The having the medical side and being evaluated from that would determine much more, and like his behavior and understanding that, did you know that this crime was wrong when you did it? Do you know right from wrong, kind of thing.
And being on the spectrum does not mean that you don't know right from wrong. Like you said, the spectrum is a very wide range of things, but I don't like that, because already there's so much stigma that is attached with these mental health diagnoses. And when you do that, it makes it seem as if you are claiming that someone who may be on the spectrum is more likely to commit heinous crimes. And I hate that. But I have a feeling that this is a separate issue from the medical that we're seeing being questioned about in these transcripts. I have a feeling that Bryan may have a medical condition that we aren't aware of now, and that is what they're referring to. We just haven't gotten there yet.
Gotcha.
Okay, so let me play this clip. All right.
Headlines each day right now. A lot of people paying attention to this until the trial that's coming this summer. This could potentially set a precedent with a lot of implications going forward. After all, there are people on Arizona's death row right now who have documented autism diagnoses. A criminal defense attorney says if the defense team gets their way on this, we'll likely see this go all the way up to the U.S. Supreme Court.
All eyes on Bryan Kohberger, months before his high-profile murder trial is set to begin. And now, an unexpected twist: autism and what that means for the death penalty.
Defense teams always don't want to reveal their cards until they have to.
Russ Richelsoff is a criminal defense attorney unaffiliated with the case but familiar with the facts. The 30-year-old is accused of stabbing college students Madison Mogen, Kaylee Goncalves, Xana Kernodle, and Ethan Chapin to death at an off-campus home in Idaho. Xana has family here in Arizona. A new court filing this week shows the defense team has filed a motion to strike the death penalty from the case, citing an autism spectrum disorder, and a motion to keep those new records sealed.
And I'm curious to know the date of that, because Anne was just trying to fight to get this off the table because the anxiety that it's causing leading up to trial, right?
Yeah.
It seems like she's trying to pull anything out right now, Shay.
But she has to do this, though,
Yeah.
especially if they
Oh, yeah.
found this out like throughout his time incarcerated, even before that. Like they have, I mean, I think she's doing the right thing. Absolutely. I just think that
Absolutely.
it's something maybe not as common in such a high profile case that people have seen put forward out there. And I could be wrong, but to me, it's the first time I've heard that. And so it's kind of a new avenue to kind of think about, especially whenever in Idaho, you can't, plead insanity, but
Right.
there is this exception right here when it comes to mental impairment.
And yep, I don't disagree with anything you're saying. I'm sighing because I'm like, oh, it seems like she's grasping at anything right now, which again, it's her job. She's doing her job. I'm not judging what she's doing versus, oof, like you're trying to strike the death penalty, get it off the table for a quadruple homicide because my client's on the spectrum, which, was news to us, but okay, that, I'm not surprised about that. But I'd love to know, again, is this a diagnosis he's gotten before he was incarcerated or after? And when I say that, that doesn't mean that means it's not legit. I'm just curious. These are all factors I ask myself.
Yes, and I know I said I wanted to tread lightly, especially on panel, but like I shared earlier, I understand why this has to go through, but he was a PhD student in the criminology program, so he's got to know right from wrong. So that's the just hard part for me, like this is a passion of his.
Yeah. And well, being on this, again, I hate the stigma. Because being on the spectrum, usually you're far smarter. Your brain just works a bit differently with things, right? Not less than. And making it seem like he wasn't capable of knowing right from wrong when that, and of course, again, spectrum, it's a very large spectrum. And I'm aware that there are two completely polar opposites, but I don't like, and I felt this way even with Letitia, turning around and claiming, DID. And I felt this way during Quentin Simon's case when all this talk was happening about who was in that house. Leilani's brother diagnosed autism. Maybe he did it. It was so hard for me to see that happening because people fear the unknown, even though today in society we know more about this type of stuff than we've ever known. But people, there's still a stigma with it. And you're looking for a fault, so to speak, in a killer's brain. And it's just, I hate that. But I'm not surprised if he did get a diagnosis, and Anne is, of course, she's advocating for her client and going to try to use anything to get it off the table. But originally when I heard this, I was like, oh, is this possibly that medical, like identifying via medical records that we were reading about? But no, that doesn't make a sense to me. I mean, I guess maybe if it's in the markers and I don't know enough about that, but I have a feeling that no, this is separate from that.
I mean, according to Anne, everything flows. So.
Yeah, that's true.
I mean, we don't know.
That is true. Okay.
This is the first time the possibility of autism has been brought up in this case, years after the murders. Richelsoff says there may be a reason why.
The interesting thing about criminal law is the prosecutor is required to disclose pretty much everything. The defense is only required to disclose what they're going to use. It's possible this diagnosis has been around for a while and they've, made this kind of last minute decision to go forward with this argument.
But how would this hold up in a court of law? Richelsoff says in 2002, the U.S. Supreme Court ruled people with intellectual disabilities can't be subject to the death penalty, at the time deemed mental retardation, a phrase that is no longer used. But medical experts say not all autism diagnoses rise to that level.
I question whether a court will just make a blanket ruling that a person who has autism spectrum disorder is not eligible for the death penalty.
In 2023, Brian Patrick Miller, the man known as the zombie hunter who committed the canal murders in the 90s, was sentenced to death for the killings. Miller not only had diagnosed autism, but also dissociative amnesia. Richelsoff says if a judge were to rule in favor of Kohberger and the death penalty was stricken due to autism,
I'm certain the state would appeal it. I think that's a question that would ultimately get to the U.S. Supreme Court.
And I just have to pause because I look at people like Brendan Dassey, and I think that there is extreme injustice with Brendan Dassey, and he has such established. I don't like, so I can see absolutely mental health diagnoses becoming a talking point in cases and in regards to inmates. I do, but and I don't know enough about Bryan, to be fair. Everything that we do know about Bryan is very limited and the majority of it is hearsay. But I don't know, like,
but he's a criminology student, so that's that's the whole thing right there. You're just like, but this.
Oh God, name changed. Well, I wish you and your family, I don't even know what, like, just nothing but peace and resolution of whatever you think is best for that. And I'm so sorry for your loss.
I'm sorry.
And just, buddy, I think that that's such a great question, but such a difficult question to answer. So just, buddy asks, what's worse, death penalty or natural life? And I think that that's a great question. And I cannot tell you, at least for me, and then I'll let Shay answer, but I can't tell you what I think because I bounce back and forth with the two. I'm not pro death penalty. I'm not against death penalty. I'm a case by case kind of feeling. Like, I believe Letitia should be absolutely anything involving children, like, I'm not to weigh one life as more significant than another, but there's just certain crimes where I'm like, no, and
well, they have to qualify, like Texas. Like, I know you would qualify when it comes to like children specifically and their deaths. So it's not like they're just issuing out the death penalty to anybody and everybody. It's got to be under egregious terms, but per state,
right.
But you remember his mom wrote in about the article about Ted Bundy, and his death penalty. So and she was very much against it.
Yeah.
Mm-hmm.
I don't know. It's hard.
And it was interesting they pulled up that the canal killer, because I remember actually watched a couple documentaries on him. That was a very eclectic guy. Like, he seemed like he was really part of the community. People like adored him. They never thought it would be him.
Yeah.
It was wild.
Same with BTK. Same with Ted Bundy. Like, we've seen it a lot.
Right.
And then the U.S. Supreme Court would make a decision.
It's still unknown if there has been a concrete diagnosis for Kohberger or if the defense team is seeking a diagnosis. This also comes after his defense team tried to get the death penalty removed earlier, claiming it was unconstitutional in this case for a variety of reasons. As of now, Bryan Kohberger's trial is set to be...
See? So we've tried other avenues of getting it thrown out and saying it's unconstitutional, and the weight of knowing he's up against the firing squad is just too much for Bryan to handle. Nope, that didn't work. Okay, well, he's on the spectrum. Okay, maybe he is. I'm not saying he isn't. I'm just saying, ooh, she's pulling out all the stops here, guys.
I guess the question is like I try to put myself in everybody else's shoes. Is like, say like the spectrum stuff aside, as we just found this out. I felt this before was, you know, I know everybody looks at death penalty in different ways, and we all have opinions. But I think of, if he is the person, he is factually, guilty. If he gets convicted, that he took 4 lives, and they never get their families back. So I guess it's like you're scared if you're scared of the firing squad. I'm not saying that's what he said, but
I don't
you know,
get what
you
that
know,
means, though. But sorry, I don't understand what that means, though. The autism has nothing to do with height and strength, right? That's like look at Ed Edmund what, oh my god,
Edwin Kimber.
yes, thank you so much. What was wrong with me?
He's my
Look
favorite. Sorry, I
yeah
shouldn't say that.
Look at Edmund Kemper. Okay, he's a killer and he happened to be massive. Of course he could overpower you. What does that have to do with, unless I'm misunderstanding what you're saying, but like the autism has nothing to do with, well, hey, this person is, like this person you babysat was 6 foot and could overpower you. Okay, and then they may have been 5 foot and not able to overpower you. What is, I'm not understanding the correlation you're making.
Maybe we just move on.
I mean, unless I'm literally misunderstanding or misinterpreting, but you're saying I babysat a boy with high spectrum autism until he was 16 and he was 6 foot and could overpower me. Bryan is not using that as an excuse. Okay, what, like, I just don't understand what his height and weight it has. That's like, say, like, there's a big kid, right? We all have first graders, but there's the one first grader that looks like a fifth grader. Are you saying he isn't accountable for the damage he does because of the size? Like, what?
I don't think anybody is comparing like what they're physically capable, what people are capable of. It's more of, we've already seen the approach to take the death penalty off the table. That was denied. And then we were going over the transcript, which we never got to see the hearing. It talks about medical stuff, and then this autism thing pops up.
Right.
It's interesting, but like you said, like I think the most important part is that because of it being because of it, it would be more fall under like the Supreme Court possibly to look at, because that would have to be weighted somehow. Like I don't believe that's a judge to weight that. There would definitely be professionals to advise. Maybe I don't know how they would do that. I think it's interesting though.
I would very much like to know if there was a prior diagnosis or not. And this is how I already feel currently. And I'm sorry if I'm going to upset anybody, but I'm just going to be honest. You could find doctors to diagnose anything. They overdiagnose these days, in my opinion. That doesn't mean that diagnoses aren't genuine. Absolutely, there are. But I'm just saying we see it all of the time. The same way we have Dr. Dorothy Lewis, right? Who is extremely a good, amazing expert in her field. And then she went overboard with the dissociative identity diagnosis. And she was able to, in her opinion, diagnose Letitia Stout with DID. And then you have another expert who said, no way, absolutely no way. So all I'm saying is it would make a big difference to me. And I'm not saying I would exclude the possibility, but did he have a prior diagnosis, or did this come once he's incarcerated?
I think that's a great question.
Yeah. So I'm curious to see where it leads. But all right, guys, let's keep that in mind. I'm going to do a little bit more research because I would like to look more into, hey, is this identifiable in DNA, let alone like a touch DNA, right? Like a very small, I don't know. I'm going to look more into that because you guys already know that medical, the common medical theme is coming up and identifying through a medical diagnosis. And the example they've been using is cancer. That doesn't mean it's cancer. That's just the example that we've seen. And so I would very much like to look more into that and explore the possibilities of what that might mean.
Absolutely.
Yeah, absolutely, Katie. Absolutely. And there's a crap ton of misdiagnoses too. So all I'm saying is, woo, if you're looking for a diagnosis, you could get a diagnosis, trust and believe. Yep, exactly. Gidget, exactly. That's all I'm saying. But okay, this is part 3. We're going to be finishing this unsealed order from the court hearing of the other day, well, of the January 23rd. And then we're going to be moving into the Frank's motion, okay? And so this is going to be our last witness, defense witness. This is the fifth witness. This is Leah Larkin. They had just gone on a lunch recess at this point, and so now we are returning from the lunch recess. We'll just keep the same theme that we have been doing this whole time, and so I will remain Ann Taylor, and then we will have Shay to be not only Judge Hippler, but Leah Larkin. So we are returning. We have Judge Hippler.
Happy because Leah Larkin kind of talks like me, so I don't have to change my voice. Okay. So, all right. We are back on the court. The defendant and counsel are all present.
And
Defense may call their next witness.
Thank you. Please take a second, hit that thumbs up if you haven't already. And thank you all so much for being here. We'll gift out a Patreon member midway through. So thank you. All right. So Ann Taylor, Dr. Leah Larkin.
So go ahead.
Thank you. So Leah Larkin, PhD, duly sworn in, direct examination. Ann Taylor, good afternoon.
Good afternoon.
Will you say your whole name?
Yes, my name is Leah Larkin, and it's spelled Leah, and the last name Larkin.
And what do you do for work?
I'm a genetic genealogist.
What kind of background and training do you have?
I have an undergraduate degree in biology from Swarthmore College in Pennsylvania, and I have a PhD in biology, specifically in the field of botany from the University of Texas at Austin.
And how long have you worked in genetic genealogy?
I started doing it as an amateur in, I believe, 2013, and I started taking professional clients in 2016.
What does that mean when you take professional clients?
Most of my clients are people like an adoptee or somebody with an unknown father who's trying to identify that particular relative. So I can use their direct-to-consumer genealogy DNA test, build family trees, and work to identify their biological family.
So your work happens after the SNP is produced?
Yes.
Do I understand that right?
Yes.
Do you know what whole genome sequencing is?
I do. I have not done it myself, but my training in biology, I understand what it is.
Based on your work in genealogy, are you aware of what kinds of things are contained in the whole genome sequencing file?
Right. As few of the earlier witnesses have said, the genome is basically the blueprint. It's the instruction manual for your body. So first of all, it makes you human, but it also can determine your hair color, your physical traits, your eye color. And there are a lot of genes that are going to be associated with other things, like whether you have a propensity for Alzheimer's or your height, your weight. Basically, all these traits that make us unique for the most part are coded in our genes, our DNA, and one or more genes.
Pause. I know it's not trial, but the witnesses are allowed to be in the courtroom when prior witnesses are testifying?
For the expert, yeah.
Okay. Ann Taylor, is there any suspect in your field where is there any aspect in your field where medical information can be known?
Yes, so the DNA tests that are used for genetic genealogy are called microarrays. So when you spit in a tube and send it off to one of these companies, they're going to do what's called a microarray. A microarray test was designed for biomedical research. They weren't designed for genealogy. Genealogy was like an afterthought. These are tests that were created specifically to target physical traits, health traits, and it just happens to be useful for genealogy as well. So even if I do a test and don't look at those traits, they're still in the data file.
This is really interesting, Shay. Like there's something with medical, and I'm dying to know what it is.
Yeah, I really felt like Leah would probably be the best one. I know she's kind of been a pioneer of it, a little alongside like CC Moore and them.
But Anne isn't gonna release anything she doesn't have to release, and if she's holding in on this, like we're not gonna know.
But what if it just is the autism? Is like, or do you really feel like it's something bigger?
I mean, I'm like, no way. But I have to educate myself more, and I have to understand that Anne is willing to bend as much as she can. And she may, like, if there's any room to where she can use it, then it may be that. That's why I'm going to have to look into this a little bit more, because it's going to be bothering me, you know, like, can she? And we have the prosecution who's also using that same terminology, but they're using cancer as the example. And so I can't imagine, I would imagine another mental health diagnoses if they were going on that direction. You know what I mean?
Mm-hmm.
What do you think?
I mean, I do think the autism is the medical thing. That's just me. I've known that that you're able to find it in GNA, like in markers. Yeah, I mean, they've done tests even in utero as well.
I know that they can, but I don't know what that testing is. Like, what do they need from that?
So,
Like, what is?
okay, but basically, I think we're like, it's not saying that you absolutely have it. It's saying that within your DNA, it's inherent to you.
Okay.
Like, you know how like you may be able to, like, say, like, somebody has like cardiovascular disease in your family.
Yeah.
That doesn't mean you always get that.
No, I know.
And I know that that's not, like, I know it's different in the mental aspect, because like it is this like huge spectrum. So I know we probably feel like there's more to it than just thinking of something that's a lot more of like maybe how we see of a physical health versus a mental health. Does that make
I'm
sense?
trying to figure out if they would be able to
Biological.
determine that from DNA left on a sheath, because what they're saying is not so much, hey, once we have his DNA. No. Once they have the DNA from the sheath, are they able to build a profile and know within that DNA that he had autism? That's what I'm stuck on. Would you be able to determine? Because I understand what you're saying. Hey, you're able to do this testing in utero. Yeah, with that DNA. What about the DNA left on a sheath from a possible fingerprint? From fingerprint, you could figure out a diagnosis of autism?
Yeah.
I highly doubt it.
Well,
I mean, if you could, then I got to look into that, because that's mind-blowing to me.
yeah, I mean, you have DNA like in your cells, and that DNA, like, those strands are long, and that's what they were talking about. Like, there's so many different letters, and like the alleles and what they mean. So it is a blueprint. She's right. And
I'm going to have to
it's
look into that.
interesting how
That's
micro it
crazy.
is.
Yeah. That's crazy if they can. And I'm not familiar with that at all. That's why I'm kind of like stuck here. And I'm going to have to look into that more, because that would be very interesting.
Yeah, I mean, it is very interesting. Maybe we can find a little bit more on it as it comes out, but
Yeah.
yeah, it says. I mean, it says that it could be detected both on your mother's and your father's genetics, like that make you up your DNA.
But
So
would
it's
they
like,
they would be able to determine that from like touch DNA?
it's DNA. DNA is just DNA.
But I don't know. I don't know how much they're able to pull. I don't know. I'm gonna have to look into this more. I'm gonna be stuck. But that would be super interesting. I guess let's see what else Leah says. So Anne asks, when you get the work, do you have to make a choice as to what kind of database you're going to do your research in?
Hold on 1 second. All right, let me put the phone down. I mean, I think it's been a disputed topic, so it really would be interesting. Maybe we could find different sides of that. I'd like to know more too.
Yeah.
Before I go down that little rabbit hole. Okay, so yeah, so if I'm taking a client who is, for example, an adoptee, I will have them test at Ancestry and 23andMe. So those are two companies where you actually have to send in a spit sample to get into their databases. They don't take data files from other sources. The most sorry, you have to say something?
No, you're good.
The most cost-effective way to do this for an adoptee is to test at those two companies and then take one of the data files you get from, say, Ancestry and upload it into the smaller bases. That way you don't have to pay for a whole new test. You don't have to wait to mail it off and have the lab run it and get the results back. You can normally get your results in a day or two after you do the upload. So for an adoptee, there aren't really restrictions on which databases you can use because they were all generally created for amateur genealogists.
So we've talked a little bit today about databases that have restricted use.
So, oh, yes, sorry.
So what does that mean?
So forensic genetic genealogy, which is also sometimes called investigative genetic genealogy, and then there's the combination FIG, just because we can't decide, that is restricted to two main databases. There's family tree DNA, which we call FTDNA for short. And then there's GEDmatch, and those are the only two databases of any significant size that allow FIG searching. Ancestry forbids it, 23andMe forbids it, MyHeritage forbids it.
Does GED match have two sides to it?
Yeah, actually, both GEDmatch and Family Tree DNA have a specific upload process for forensic kits. We call these test kits. No, test a kit? What the hell? We call these test a kit.
Sorry, that sounded really funny.
I was about to say testicle. I don't even know what the hell
Yep.
I'm doing. Get me off here. All right. So if you're normal, regular adoptee, you can upload through the main layperson portal. But if it's a forensic kit, it's supposed to go through a special upload process. GEDmatch, they call that GEDmatch Pro. Family Tree DNA does not have a special name for it to my knowledge. But there is a special process you're supposed to go to. And those kits that are uploaded through the forensic portal are restricted in which other kits they can see. The idea is that if you don't want to participate in a forensic search, if you're a layperson and you don't want to participate, you can opt out. And so a kit that is uploaded through the forensic portal should not be able to see a layperson kit that is opted out.
Do you know why these databases have these different, I guess, abilities or rules?
Yeah, so I'm sure we're all familiar with the Golden State Killer case. At least we've heard about it. That was the first big criminal case that was solved using this type of genetic genealogy. There had previously been one doe, unknown remains that had been identified a few weeks earlier, but the Golden State Killer case is the one that got all the media attention. On the one hand, there were people who were really excited about the prospect of capturing violent criminals using this method. At the flip side, there was a lot of genealogists who were really concerned that they might be drawn into criminal investigations without their knowledge or consent. Sorry, I kept going.
No, you're fine.
And so the community split. There were a lot of Facebook groups. A lot of genetic genealogy is just done through Facebook groups. And some of these Facebook groups just basically forbid it. You can't talk about this at all because it was causing too much conflict within the community. I went to a conference shortly after the Golden State Killer case was announced, and I was a speaker. And they pulled all the speakers aside and said, don't talk about it at all. You're not even allowed to mention it at all. This is how contentious it was in the community. So the databases, realizing that this was a problem, so Ancestry, 23andMe, and MyHeritage all very quickly changed their terms of service to say, no, you can't do this on our databases. GEDmatch and Family Tree DNA, over the course of the past few years, have kind of evolved these systems in response to public outcry about privacy and consent, and also in response to some breaches and some missteps on the part of the companies themselves, and on the part of some of the genetic genealogists. So they evolved these systems to allow the users to opt out if they don't want to participate.
Sorry, I was typing to Claudia.
No, you're fine.
So the public outcry, That was people that didn't want their profiles searched by law enforcement?
Right. Prior to this, there had been occasional discussions in the genealogy community, people saying, "Oh, the cops are going to get our data," and other people were like, "No, they only use CODIS, so they're not going to use our databases." And it turns out they were. The Golden State Killer case was being investigated. I'm not sure exactly when it started. I think 2017, and he was arrested in April of 2018. So law enforcement or genealogists working on behalf of law enforcement were in fact using the databases without the knowledge or consent of the regular person genealogists who were in the databases.
So, was it 2018 when the terms of service used and people's privacy rights were recognized?
So there's a whole series of changes to the terms of service. So I can't speak to precisely which dates in which databases and which changes. I recall that MyHeritage, within a few weeks of the Golden State Killer being arrested, changed their terms of service to explicitly say not in our database.
All right. So, let's talk about this case. Were you brought on to help us in this case?
Yes, I was brought on to help you interpret and understand what was done in terms of the genetic genealogy for this case.
What did you look at to do that?
Well, it's been a bit of a struggle getting all the material I would like to look at. So I have seen basically photos of a giant kind of poster scroll of the family tree that I believe the FBI built at ancestry.com. I've seen pictures of a whiteboard. What?
Not a
And
whiteboard.
load in which they have which they sort of like hand wrote on the whiteboard a descendant tree. So basically, looking at some ancestors and mapping out the descendant lines leading to certain DNA matches. I've seen communications between, in some cases, I can see who the recipients are, and some I can't. But I've seen a lot of email communications about the case. Do you want me to go on?
No. In the course of your work to try to help us understand what happened here, did you learn that first Othram worked on the case and then the FBI took over?
Yeah, so Author, I believe they were contracted based on the invoice I've seen. They were contracted to do the lab work. So to actually generate a S&P profile, upload it to GEDmatch Pro and Family Tree DNA, presumably through the approved portals. And then I believe they were contracted to do the genetic genealogy, but they were told to stop work, I believe on December 10th. And I've seen the preliminary report they wrote.
All right. Have you had a chance to look at what happened after December 10th?
So after December 10th, there was some email communications between the one I think was most interesting to me had the names redacted and it contained screenshots. So just to backtrack a little bit, the author report reported two main DNA matches. One of them shared 70.7 centimorgans of DNA.
And hold on, I know the court reporter speaks, but I just want to write that down. Page 150, two main DNA matches for Othram.
The four brothers.
Yeah, I'm curious about that. So the court reporter says, I'm sorry, 70.7?
70.7 centimorgans. Do you know how to spell that? CENTIMORGAN. And we just abbreviate it to C capital letter M. The other one I think was 60. And Author's report specifically said those are low matches. Author figured out how those two people were related to one another. I believe they were third cousins to another one. And based on how much DNA they shared with the crime scene profile, they thought that the individual who contributed the crime scene profile was descended from the second great grandparent of those two matches, a man named Blank and his wife Blank. I believe were their names, and they were born in the blank.
Hmm. So when Othram quit work, were they following a family tree that they could have led and come to Bryan Kohberger?
Yes. So, based on my initial review of what they did, the crime scene profile was most likely descended from blank and blank, or perhaps from one of their siblings.
Husband and
It's
wife. Okay. Sorry.
it's okay.
Interesting.
And there's a lot to, I think Leah was probably going to be the best
Yeah.
because she's actually already done some testimony.
Yeah, I know. Yeah, it's interesting.
Now,
Hey, Pam.
now after doing this, I actually kind of want to go back and rewatch the
Hmm.
last hearing
I
part because
know.
okay, so it's hard to tell with DNA because it's not. Not all third cousins share exactly the same amount of DNA. Some share more, some less. It's just kind of a statistics game you play. That couple had or blank children. And so there conceivably could have been hundreds of descendants of this couple. I haven't seen the full tree. I've just seen that they had blank children. Othram chose one of those children and had tracked down, I believe, grandchildren, and there were 4 brothers.
4 brothers. Okay.
So the 4 brothers were the grandchildren. Okay. So they recommended testing one of those brothers to get more DNA to get a closer handle on where their crime scene profile might fit into that family.
Do you think they contacted Brian's dad? And he denied?
Well, this third cousins. Like this is we're separate.
Oh, okay.
So no, I don't.
Oh, wow, some golf girl. Okay, so Anne says, so when Othram stops there and the FBI takes over, you told us you saw something from Ancestry.com. Would you have expected to see any other kind of file with that file?
So this was basically like a giant poster-sized printout of information from that family tree. A family tree, when you build one at Ancestry, it's stored in a specific kind of data format, or more precisely, you can download the file in a specific type of data format called a GEDCOM, a GEDCOM, and it's a universal file format that for genealogy trees. So you could take a GEDCOM file and you could open it up in a standalone software on your laptop. You could upload it to a different genealogy company. I have a GEDCOM file for every single client case that I do. When I'm finished with an adoptee case, I basically give my client the GEDCOM file so they have a record of all the work that I did. And I would have expected the FBI to have that as well, but they did not turn that over.
You didn't see one of those?
I did not see one of those, no.
So knowing that Othram finished their work on December 10th, and then the FBI took over, and we've heard that by December 19th, 9 days later, they made an identification. Is that significant to you?
Yeah.
And why is that?
Because Othram's matches were, as in their own words in their report, those matches were low. They were recommending testing these 4 brothers to get more information. If you went out and if you approached those men, and even if one of them said, yes, you can test my DNA, the testing itself would have taken some time, getting a kit to a person, getting the spit, sending it into the lab, having it analyzed, and it would have led to the crime scene profile because it wouldn't have led to the crime scene profile because it was the wrong family branch. So going from low matches to an ID, or at least a tip, whatever they were calling it, within 9 days, that right there told me they had gone into a database they were not supposed to be in.
Ooh, big allegations. Okay, Leah Larkin, I see you. Were there other ways that you were able to confirm your belief?
Yes.
What was that?
So one of them, in one of those email communications, I believe this is the one that had both the sender and recipient redacted. There were screenshots from GEDmatch, and I believe it said so there were screenshots. How do I put this in GEDmatch? GEDmatch has a very open system. So if you are in GEDmatch and I am in GEDmatch, and let's say we were cousins, I could go in and look at my kit and I would see you in my match list. But I could also go into your kit and see me in your match list. GEDmatch is just a super open database in that way. Any kit in the system that is public, you can see their matches. The one exception, however, is that if there are forensic kits in the database and I'm a layperson and I'm looking at a layperson kit, I can't see the forensic kits. They are invisible to me. But there is an email communication that has a match list from the perspective of somebody who only used the initials SC. Okay. I have no idea what this person's real name is. In the database, they are called SC. This screenshot is taken from the perspective of SC, and there is a match of the forensic profile from SC's perspective. That tells me that the forensic profile was uploaded through the regular GEDmatch portal and not the GEDmatch Pro forensic portal, because it should not have been visible to SC, and the email says, "This one's ours." And the other thing is that GEDmatch will also tell you how many days a kit has been in their system. And for that kit, for the match to SC, it had been in the database for 1 day. But Authorm had uploaded it. I'm not sure exactly when, but I would say 6 to 7, 8 days prior. So it should not have said the kit was only 1 day old.
Okay, I need to jump back for a minute.
And I know that the open hearing that goes over this part, like I know where that's at. Like, I really think we should definitely watch that, or like watch that, because there is more to it. Because Anne like throws in little like like it was, did you watch it? I don't know if you did, but like she tries to like talk about what happened in the closed hearing part. Like, I don't know, that's kind of that's when he had the saying of like, do the DNA every day on Sunday.
I can't see the forensic kits. They are invisible to me. But there is an email communication that has a match list from the perspective of somebody who only used the initials SC. I have no idea what this person's real name is. In the database, they are called SC. This screenshot is taken from the perspective of SC, and there is a match to the forensic profile from SC's perspective. That tells me that the forensic profile was uploaded through the regular GED match portal and not the GEDmatch Pro forensic portal, because it should not have been visible to SC. Okay. So Anne says, so based on that email and what you saw, it confirmed your belief that the FBI used a non-allowed.
Right. So that was one. There were several lines of evidence. That was one of them that stood out to me early on, that they had uploaded through the layperson portal of GEDmatch so that they could see all the people that were opted out. There were a couple of other matches. One of them was actually 250 Cinnamorgans, which is something we get excited about in genealogy. And one of them was, I think, was closer to 70 that were not in the Authorm report. If Authorm had seen the one who shared 250 Cinnamorgans, that would have been in their report. Like, their genealogists are good. They know what they're doing. They would not have ignored a 250 Cinnamorgan match. And based on those other two matches, at that point, I was pretty sure they had gone into the MyHeritage database.
While you were reviewing this information so you could learn and try to figure out what happened here, did you have any ability to call anybody from the FBI and say, hey, what's going on?
I don't know who did the genealogy work at the FBI.
Why is that?
It's not in the information that we received.
Is that the part that was redacted?
I don't know if it was redacted or if we just never got it. So there was that one email that had a redacted sender and a redacted recipient, presumably. Those were the people doing the genealogy work. But other than that, I have no idea who did the genealogy work at the FBI.
And I just want to pause real quick because I see Andrew, you say they could plant it. That is not even what Anne is saying right now. Anne is trying to show they went through the back door and accessed it as if when they weren't supposed to. Okay, so it's not, I just want to be careful. We're not making jumps here. Let's take it for what it is. It's, hey, you cut a corner and you went through a way that you weren't supposed to, not that the evidence or the DNA was planted. Okay. Which this is still going to be potentially an issue,
No,
or it
it's
may
actually
potentially not be, because at the hearing, the second half of this hearing, the judge even said, okay, even if, while they were talking to prosecution, even if the FBI themselves went and used a backdoor, right? They went through a way to get this match that they weren't supposed to. This is not evidence they are submitting, and it should not fall upon the prosecutions because they're not submitting it as evidence against Bryan Kohberger.
yes, and then also they did not break a law. There is policy and procedures that were within my heritage, and there's a specific note that at any specific time that the DOJ and law enforcement can access the system, and that's what they did, and that's what you find out later on.
Yeah. So I just want to, I don't know, like with this case, I just don't want to make the jumps. Okay. Let's just kind of stick to what it is. And Anne isn't even trying to make that implication. Okay. So Anne asks, are there any other ways the FBI went where they were not supposed to go? Because again, she's not saying they fucking planted. She's saying, hey, it may be my client's DNA, but you weren't supposed to make the match that way. And let's also remember, this is 4 lives, 4 young, beautiful lives that were taken. So I understand if you're in the mind state of, well, hey, I'm leaning towards not guilty, and that's fine. I'm not going to try to convince you otherwise, but I just don't want to become confirmation biased where we're looking for something that isn't even there, or information that's only going to align with our beliefs. The literal words are right here in front of our face. Let's just focus on those.
All right. So there was one piece of information in the discovery material that I did review. I believe we asked them to turn over the match list. And they were like, oh, we can't turn over the whole match list because it was 20,000 people. And that actually right there was a big tip off, because if they had only used GEDmatch Pro and only used Family Tree DNA, I think at most they could have gotten to about 10,000. So right there tipped me off that they were in a database that they shouldn't have been able to be in.
Okay, Andrew. During the course of our work to try to understand what happened here, did you assist us with reviewing documentation and teaching us what else should have been there that we needed to ask for?
What specifically?
Well, about the databases they went in and the match list and...
Right. So we talked about what you see in a match list. We've talked about the fact that you can download the match list as Family Tree DNA. There's just a click button to download it, and you'll get a CSV file, which you can open in a word processor or you can open in a spreadsheet program. At GEDmatch, you can also get the whole match list. So you would have gotten that. I tend to do that for my clients just so if I'm not online, I can still work through their materials and I can report that back to them.
And did you testify in a motion to compel hearing to try to get this information so we could tell and confirm what you believed about the FBI going into a non-allowed database?
Yes.
And do you know if sometime after that we received confirmation that they did?
We did finally get a letter from the FBI in which, so we specifically asked to know which of the matches were in which of the databases, and they did not tell us that. But they did give us a list of the databases they had uploaded to, and it included Family Tree DNA, GEDmatch Pro. Those are the 2 databases they're allowed to use. But it also listed GEDmatch, not GEDmatch Pro, but GEDmatch. They're not allowed to go into the regular GEDmatch portal. And then finally, they admitted they had uploaded to MyHeritage.
Ooh.
So at worst, they would break a TOS
Yep.
policy with them, but there's also still disclosures that they bring up. So this is interesting, and I think that's the reason why the DNA got passed to the FBI, because of those fine lines that would be able to let them get there. That's
Yep.
just my opinion. Okay.
Mm-hmm. Well, what they're saying though, Michelle, is that for the people who opt out, there is like a rule that they could do in some instances, but for the most part, they went in and they accessed when they weren't supposed to.
Well, and my heritage isn't in the group that is like you're not allowed to be in at all. Like my heritage was a smaller one, and I think that's where they had like some leeway there.
Mm-hmm. So Anne says, Your Honor, I am at D26 and I could pass this copy to the court. I would ask that it be shown to the witness first.
What's the red number on it?
Your Honor, the red number is 999.
Notice of in-camera submission?
Yes.
All right, go ahead.
So Dr. Larkin, will you thumb through that? It's towards the back page.
Okay.
Do you recognize that?
Yes. The second to the last page, it says, below are the genealogy services utilized by the FBI.
And what does that tell you?
It says Family Tree DNA, GEDmatch Pro, GEDmatch, and MyHeritage.
Thank you. Would Your Honor like the copy they have there?
I think it's part of the record you submitted, so I have a copy.
Okay, thank you. So just give me one moment to check with my team. All right, so I do have another question.
All right, go ahead.
What is Prometheus?
Prometheus is a third-party site, so it's not part of Ancestry, not part of MyHeritage. Actually, MyHeritage owns it now. It's a site where you can take the S&P profile that you get from any of the companies and upload it to the site, and it'll basically look for medically informative S&Ps in your profile, and it will do reports on them. I think it's like, I don't know, it's like a normal fee, like $12 or something, and it'll do a report of all the S&Ps that you have in your profile.
If you had my SNP, you could do that and find out.
Yes, I can do it on if somebody has done a genealogy test for $12, I can put it into the Prometheus system and get trait reports and health reports.
And how extensive is that information you could get?
It's pretty comprehensive. I mean, you will get reams and reams of reports. I should say that how do I put this? There are a lot of traits that are controlled by multiple genes. And so if a trait is controlled by multiple genes, I can't say for certain, yes, you're going to get Alzheimer's, or no, you're not going to get Alzheimer's. It's more of a risk factor, but you can look at the multiple reports and see if they're, for example, giving you an increased risk of Alzheimer's or whatever other traits are in the system. If you have an increased risk of breast cancer, prostate cancer, anything else out there.
For $12?
Yes.
Thank you. That's all my questions. Okay. Maybe this is autism, man. Oh, wow. Because Leah gave us, listen, for every other prior witness, okay, it's been basic medical cancer, right? Cancer's like the go-to major, I feel like, example people would give. But Leah would already know where it's going. And Leah used Alzheimer's.
Yeah, I thought that was interesting, especially because, cancer is a genetic mutation. And
Right. Maybe this freaking is about the autism. Wow. All right. This is interesting. So we have cross-examination. I'm going to now be Mr. Nye. Shay is still going to be Leah Larkin. So Mr. Nye starts. Good afternoon, Dr. Larkin.
Good afternoon.
So you testified that when people come to you wanting to do genealogy tests, you recommend Ancestry DNA and 23andMe. Is that correct?
Yes.
And one of the reasons you recommend those two is because they have the most users in the database. Is that correct?
Yes.
And the reason why that's important is because when you're looking for ancestry, really the best database for you is the one that has your closest relatives in it, right?
Yes.
But you can't know that until you use the database. So you just use the one with the most users.
There are two reasons to start with those two companies. One is because they have the largest two databases. And then because you cannot upload into those databases, you have to test with them. You can test at Ancestry and then get it into MyHeritage and Family Tree DNA and GEDmatch databases for trivial amounts of money. Whereas if you test it at Family Tree DNA first, the only way you're going to get into the Ancestry database is by doing another test. So I always recommend starting with the biggest, and then if you want more databases, you can upload into the smaller ones.
And one of the reasons you might want more databases is so you can get more matches, right?
Yes.
You can gather more information that way.
Uh-huh.
And typically, that's why people are coming and asking you about these databases, is because they want more information about their family, correct?
People generally come to me because they need help interpreting the matches that they have.
I want to talk a little bit about the number of users in these databases. So we've been discussing the ones that were on that list you read from the document the FBI indicated that they had used in this case. Do you remember that list? On that list, do you know which of those databases has the fewest number of users?
I believe Family Tree DNA is currently about 1.8 million. It's not an exact number, but I think that's probably about where they are right now. GEDmatch is, I think, a little over 2 million, and MyHeritage recently announced they were at 9 million.
And when you say 1.8 million, you mean 1.8 million other people that have utilized their services and that you potentially could match with if you utilize that service.
Yes.
Is that correct? I have a couple of questions for you on this Prometheus. You mentioned it cost money, $12, I believe you said.
I think it's $12.
Why would someone utilize Prometheus instead of just reading their SNP profile themselves?
The S&P profile is basically just a list of, there's a location code, but it's going to be something like RS23744. And you're not going to know what RS, yada, yada. I don't even know what number. I just made that number up. You're not going to know what that S&P is. You're not going to know what gene it's a part of. You're not going to know whether an A or T is good or bad. Prometheus takes your data file and references published literature on what those S&Ps might impact in terms of traits, and then produces a report from that.
So even you, for example, if you wanted to know your medical information and you had your own SNP profile, you wouldn't just attempt to read it. You would use a service like Prometheus?
Yes.
No further questions.
Thank you. Redirect?
No, Your Honor. Thank you.
Thank you, doctor. You can step down. Is that the state's last witness on this issue?
Defense? Yes, Your Honor.
Pardon me, defense. I'm used to the state going first on things. I apologize. Does the state have any witnesses?
Your Honor, no. We're not going to call Dr. Middleman.
I'm trying to recall what I said about argument on this issue, whether I said we could do this publicly or not. I want the parties' input on that as we make that decision, whether we can argue the Franks and suppression issue on IGG publicly. I know your position is we should, but in light of my ruling, can you?
Your Honor, I'm going to refer to what the FBI did in here. I'm going to refer to the Department of Justice interim policy. I can probably not name the 4 brothers that the state lab tested.
Okay. Can we avoid talking about the fact of the 4 brothers? I understand that's there, but I'm not gathering the import of it on the issue, or the importance of and the import of it on the issues at hand.
Mm-hmm.
Okay. I think you could reference that there was some information that was itself insufficient to generate a profile, and I know what you're talking about.
I'm trying to think of how I could do it. I want to make sure I've made a really good record here. The record is very important.
Of course.
I think I can talk about Autism's recommendations that were attempted to be followed, but nothing worked. I think I can do that. And maybe after the hearing the evidence, if there's a ground the court really wants me to stay away from, other than saying the four brothers, maybe that would be helpful to know. I'll do my best, Your Honor, but I really want to make a good record for Mr. Kohberger.
Counsel?
Mr. Nye. Your Honor, I think we can probably do the argument publicly. I don't need to reference the brothers. I don't need to reference any of the specific names. As I explained earlier, and as the court has seen, we didn't put on evidence one way or the other as to whether the policy was followed, for example, so that part of the argument is even assuming. From our perspective, I think we could probably do the argument publicly.
I thought I made it clear what I've tried to do is to open up evidence, whether for the state or against the state in this case. That potentially is not coming into trial that could influence potential jurors. I didn't hear a lot of that today. I think the fact that there was investigative genealogy done in this case is not necessarily a secret, given that we publicly talked about that we're going to talk about that. I think the more specific things about what happened within that, it's best if we kind of refer to that more generally in terms of like the four brothers and whatnot. I think, frankly, it's appropriate to discuss how law enforcement handled the profiles that they received. I think it's appropriate to talk about whether or not those profiles, what privacy is at issue in those profiles. I think that obviously the state is going to talk about standing and other issues and your client's specific privacy rights with respect to this. So I think that's appropriate. So I think we're generally okay staying away from some of the specifics that I'm not sure that ultimately would be admissible at trial. Even if I were to say, well, admissible at trial, the whole IgG issue, I'm not sure that's going to be admissible at trial. I suspect the trash pull is going to be admissible at trial, and that genealogical match allegedly to Mr. Kohberger's father, as I understand it, and the lack of attempt to figure out, I think what I'm understanding, at least from the testimony, the attempt to figure out the mixed profile. So I think that's all fine. The preference is staying away from the specifics as to what those genealogy searches showed, more specifically that we talked about, the brothers and the names of individuals who were testified to, if that makes sense.
It does. We have an affidavit attached to the back, I think, of our reply briefing on the suppression issue. I want to make sure the court looks at that. That's admitted as evidence, and I probably don't want to refer to that publicly. Would you like my copy?
What was the date of the filing?
It should have been the 19th, December 19th.
What was the name of the document? Reply to, objection to?
This was the reply to the state's objection to the motion to suppress IgG material.
It's not shown on the 19th. Oh, here we go. It was on the 20th. What is it you want to reference in the argument with respect to this affidavit?
Standing, Your Honor. I don't need to reference that particularly. I just wanted to draw the court's attention to it.
In particular, the standing that the affidavit suggests that the unknown E was Mr. Kohberger. Is that what I'm reading?
No, that there was a sample within the trash that was Mr. Kohberger's.
Okay. I'm not sure the state's arguing that there's no standing as to the trash. I think the standing argument related to the genetic testing through the companies and to the objection to the testing of materials found at the crime scene. Am I correct about that?
Your Honor, and this is Mr. Nye. Your Honor, we did assert in our briefing standing, it was kind of in passing in the sense that we think the fact that it was a trash pull resolves that issue.
I appreciate the trash pull legal issues in terms of privacy standing, but in terms of standing of this is not Mr. Kohberger's DNA, so why am I hearing from him standing, which is part of what you argued on the IgG information.
Correct.
There's that issue. I don't see that impacted here because it sounds like some of his DNA was in that trash. And then there's the standing issue, as I understand it, related to the extent that the defense is not conceding that the DNA found on the knife sheath was Mr. Kohberger's. He has no position to object to the testing of the DNA and the knife sheath.
Correct.
I don't see there, frankly, is an argument as to the standing issue of not his DNA as it relates to the trash pool. That's just how I see it. If you think that's different and you need to make that argument, you need to let me know so I know what we're getting into.
No, Your Honor, it's not different than that. What happened is in the opening brief, they asserted there was DNA found in there, including an unidentified male. In the response, I said, well, that's not standing. You can't just say unidentified male. In the reply, they attached this saying, well, we looked at it and it was his. That's sufficient. I don't plan on arguing that point.
All right. Are we all square then?
And Taylor, I think so.
If you have a question of doubt, ask to approach and we can go offline real quick. I would rather err on the side of being cautious than not.
May I have 5 minutes?
Oh, no, we're going to take more than that because I need the public to be notified. So we're going to take at least 15, 20 minutes.
Mr. Nye. Your Honor, can I just briefly ask? We have some of the victims in the hallway. Ooh, I guess I guess they've been told by somebody that they could come in when the hearing was open.
Oh, wait. This is the Goncalves family. I knew that.
Yeah.
Okay, sorry. I was thinking it was the girls.
I know,
was
Bethany
like,
or
what?
Dylan. Yeah.
Oh, wow. Okay. So I'm not sure who would have told them that.
I don't know either. That's just what they're representing to us. We didn't understand that to be the court's.
The problem is I don't want to have to chase them out.
Absolutely. Understood completely.
Sandra can have a TV in the conference room. They can watch it on. That's fine.
Okay. Thank you, Your Honor.
And then my understanding is we can then go into the next evidentiary phase without a problem and it could be public, correct?
Yes, from our perspective, Your Honor, and Taylor. Your Honor, I think our team might be a little bit confused about that. I think we thought that Frank's might be next, but...
No, after the Franks.
Okay, so I'll do suppression IGG and then...
We'll do the argument on that, unless you want to just go straight into the evidence and come back to the argument on the Franks IGG.
Okay.
And do it together with the suppression stuff.
No, I planned to do that when I did all of the Franks to address the entire Franks. I think I'm confused about when the court wanted me to do that. If you want to take more evidence today, if we're going to argue IGG and be done, and then if the court wants to finish with evidence today, and then I'll do Franks tomorrow, argument, the proper argument.
So my preference is, because I don't want to get into an evidentiary phase of Franks other than the issue of IGG, is to argue your Franks motion next, including the IGG, and your proffer for the other Franks issues. And then we can go into the evidence on the suppression issues. Does that make sense?
That does make sense, and that's perfectly fine. I might need a minute to pull that box out after we're done with this argument, if that's okay.
Sure, you can always have a minute when you need it.
Mr. Nye. Your Honor, I'm sorry to complicate things, but just to be clear, so over here, we've split that. Ms. Jennings is handling the Franks, and I'm handling the direct IGG suppression. Is that okay if we split it that way?
Sure.
Thank you.
Again, my thought was we do all of Franks, including the IGG stuff next, because I don't want to take evidence that is then going to be said is part Franks, because if the state's then asserting it, I think I've cracked the egg on whether or not I can decide the issue prior to a Franks hearing. So that's why I want to have it wrapped up before I take more evidence, okay?
Sounds good.
All right, we'll take about 20 minutes to let the public have notice.
And that's the end of the unsealed transcripts, which
Woo!
after we go through this, like all this stuff, I think we are going to have to kind of at least jump through that, the other, like the public court hearing part of it, because now that we have more information, I kind of want to fill in some of the blanks, you know?
Yeah, so do you want to wait to do the order, or do you want to jump right into it?
No, I want to jump. I cannot wait. No.
You're like, no.
Yeah. No way, Jose. Sorry. I have to read it and we'll have to go back.
All right. How do you want to do the readings on this?
Oh, well, oh shit. Hold on. Now I gotta go back and get the whole thing. Well, hold on.
That was interesting.
It was really interesting, but they ain't no way. Because then this would get pushed off forever, because it would take so long to get through that. Let me see.
I wonder. Let me look this up real quick because we have.
Yeah, this is it. Okay. What's your question, Andrea? Hold on. I'd have to scroll to see what your question is. 1 second, hon. Been wondering since last night and trying to figure out how long the Omega Chi Ted Bundy murders took in compare. Oh crap. I remember we used to talk about this all the time. I think, crap. I don't want to say the wrong time, but it was so close.
Mm,
It was 4 a.m.
I'm looking something up about this hearing.
Damn, I don't know off the top of my head how long. I'm not sure. I'm going to have to get back to you about that, but I know it was very, very close.
Kohberger hearing. January 2025.
What are you looking at?
I think I was trying to find something that happened at that hearing that day. Sorry. I mean, they definitely brought up some stuff that'll be said, and I think probably in this Frank's motion. So we'll be able to reference that if we decide to go back.
Okay. So let's see, and we could just. So this is the order on defendant's motion for Frank's hearing. You want to read the introduction?
Sure. Defendant is charged with 1 count of burglary and 4 counts of murder in the first degree. It is alleged that defendant entered a residence at 1122 King Road in Moscow, Idaho in the early morning hours of November 13, 2022 and killed Madison Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle. Defendant is requesting a Frank's hearing, claiming law enforcement intentionally or recklessly misinterpreted and or omitted several material facts in their probable cause affidavits supporting various search warrant applications. These misinterpretations or omissions, according to defendant, affect the validity of 17 different search warrants. So Frank's, so what, I guess I'm just gonna also look at the numerical like scripts as well. So Franks versus Delaware, and so
Wait,
there was a
there's
total.
that. Hold on, but there's the second paragraph.
Yeah, I'm gonna read. I'm going to the second cliff note. So there was a where it says different search warrants. I was gonna read where it says there was a total because
Okay.
you want to read those because there also have information in there too.
Yeah, go ahead.
So there was a total of 25 search warrants issued in the investigation between December 23rd, 2022 and August 1st, 2023. For each issue analyzed in this order, the court has identified the date range for specific warrants defendant claims are impacted. So I'm just going to read what's relevant. So the state responds that the defendant has failed to make the requisite requisite substantial preliminary showing under Franks that 1, law enforcement either made false statements or omitted material information knowingly and intentionally or with reckless disregard for the truth, and or 2, that the false statements or omissions were necessary to a finding of probable cause. and then it just like references which ones those were. So, and hearing on defendant's motion was held on January 23rd, 2025. In the interest of evidentiary efficiency, the court permitted a full Franks hearing on the motion only insofar as it pertained to the alleged omission of information regarding defendant's identification through investigative genetic genealogy, IgG. On the remaining challenges, the court permitted argument of defendant's proffer as to whether defendant had satisfied his burden to warrant a subsequent, I cannot talk to right now. Let me get a drink. Frank's hearing. The court then took the matters under advisement. So there's really nothing below that really is special about that. The court concludes that the search warrants are not invalid because of the omission of defendant's identification through IgG, because that information would have only bolstered probable cause for the search. As to the remaining challenges, the court finds defendant has failed to carry his preliminary burden under Franks and therefore denies his motion for a Franks hearing.
So the standard says in a Franks motion, the trial's court determination as to whether a representation is false or whether a misrepresentation or admission was made knowingly and intentionally or with reckless disregard for the truth are factual determinations reviewed under a clearly erroneous standard. So whether a misrepresentation or omission is material is a question of law freely reviewed. The analysis shows that for a search warrant to be valid, it must be based on probable cause, State versus Fisher. So then they reference the Franks versus Delaware.
All right. And then for the analysis, for a search warrant to be valid, it must be based on probable cause. Do you want me to keep going? Or do you want to do it?
Well, I was
Oh, you can.
that analysis. Yeah, there was really nothing in that. So this, you could read it. Go ahead.
Supreme Court held that a defendant can void a search warrant and suppress the fruits of the search when the affidavit used to procure the warrant contains a knowingly and intentional or recklessly false statement that is material to the probable cause determination. Where the defendant makes a substantial preliminary showing that a false statement knowingly and intentionally or with reckless disregard for the truth was included by the affiant in the warrant affidavit, and if the allegedly false statement is necessary to the finding of probable cause, the Fourth Amendment requires that a hearing be held for the defendant. So we'll keep going. I don't really think we need to get into that.
So it just explains the analysis under Franks is a two-step process. First step considers whether defendant has made a substantial preliminary showing that the affiant knowingly and intentionally or recklessly falsified or omitted information from his or her affidavit. And the Franks court did not define this burden precisely. It is generally held to be something more than conclusory allegations, but less than proof by a preponderance. So it again references a case, and courts have said this requires direct evidence of the affiant's state of mind or else circumstantial evidence of a subjective intent to deceive. So negligent or innocent misrepresentations or omissions, even if necessary to establish probable cause, will not invalidate a warrant. Then it just references court law. So you could read the next.
If the defendant successfully shows an intentional and knowing or reckless inclusion of a false statement or omission of exculpatory information, the trial court must then examine whether the remaining information in the affidavit is sufficient to establish probable cause absent the false statement or with the addition of the exculpatory information. A Franks hearing will be required only if the false or omitted information was necessary to a finding of probable cause. If a defendant makes a substantial preliminary showing under Franks, the matter moves to an evidentiary hearing where the defendant must establish by a preponderance of the evidence that intentional or reckless falsehoods were included in the warrant affidavit and they were material to the magistrate's finding of probable cause, or that the material exculpatory information was deliberately or recklessly omitted. It is at this stage where the state can provide additional evidence for the court to consider. Here,
So they're going through the reasons why it was denied, guys.
Yeah, now it's like it's about to get into like the meat of it. So here, defendant claims that the 17 search warrant warrants issued in the investigation of the crime were based on false, misleading statements and or omitted exculpatory information in the various search warrant affidavits. His proffer is arranged by issue, of which there are 13. As mentioned, for convenience sake, the court granted an evidentiary hearing on the IGG issue. This evidence was or will be considered under the preponderance of evidence standard, while the proffer on the remaining issues will be considered under the substantial preliminary showing standard, which we just read over the part that they did.
Mm-hmm.
Can I do you want to read this one real quick? And I need to
Yeah,
take
I'm
a
gonna
quick
read.
potty break.
Yeah, go for it.
Okay,
So, A, defendant has not met his Frank's burden on issues 1 and 2, challenges to Exhibit A. In issues 1 and 2, defendant challenges Exhibit A, which is a probable cause statement that individual investigative officers appended to their affidavits in seeking search warrants. As defendant notes, Exhibit A was a working document drafted as a group effort among the multiple investigative officers working on the homicide investigation. In their respective search warrant applications, the officers submitted and swore to Exhibit A as their own, even though it was the product of a collective effort and not necessarily limited to the swearing officer's own investigation. In Issue 1, defendant challenges this approach, arguing that Exhibit A was, quote, treated as a wild card to easily get a warrant. In Issue 2, he challenges alleged misrepresentations in Blaker's Exhibit A and Exhibit A of Payne. Defendant has not met his burden under Frank's on Issues 1 or 2. First, is not improper for law enforcement seeking a warrant to swear to matters within the collective knowledge of other officers involved in the same investigation. Second, the defendant has not demonstrated in his proffers any misrepresentations or omissions, much less that they were made intentionally or recklessly or had any effect on probable cause. So we have defendant submits exhibits as evidence of group effort. These exhibits are emails between the special agents and detectives of the Moscow Police Department in which they're exchanging drafts of a probable cause statement. In addition, the defendant provided with his proffer the following 3 actual exhibits, as which were submitted by officers with their search warrants, but these actual exhibits are not identical to the drafts or to each other. Nevertheless, defendant challenges them collectively in Issue 1 on the grounds that they are largely the same statement and contain the same core set of averments. So, 1, defendant has not demonstrated an impropriety in law enforcement's execution of Exhibit A based on collective knowledge. It is well settled that, quote, statements of law enforcement officers that are based upon the observation of fellow officers participating in the same investigation carry a presumption of reliability. So the presumption extends to, quote, hearsay information from government officials who, while engaged in investigatory responsibilities, discover evidence of possible criminal activity. The presumptions arises from the belief that facts gathered in the course of an investigation are unlikely to be based upon mere speculation or tainted by personal involvement with the suspect. The defendant acknowledges that a warrant can be based on law enforcement's common knowledge, but argues that officers cannot sign a collectively drafted affidavit as their own without identifying who did the work described therein. Otherwise, it misleads the magistrate into believing that the swearing officer drafted that affidavit and performed the work therein when it was a collective effort. This hyper-technical argument has no traction under Frank's. Even if a search warrant affidavit does not specifically identify the precise source of the information from within law enforcement, it is still sufficient to support probable cause, quote, if a reader would reasonably infer that the information came from other law enforcement personnel. So in Wilson, for example, the defendant challenged an officer's search warrant affidavit on grounds that the swearing officer did not identify which facts were based on his own personal knowledge as opposed to hearsay information from other sources. 2, whether he had personally viewed the evidence. 3, the source of information from the drugs dogs trainer and experience, and for the identify of sources he contacted for the information. So noting that search warrant affidavits are not to be, quote, reviewed and tested in a hyper-technical manner, the Idaho Court of Appeals rejected that defendant's arguments, finding that a common sense reading of the affidavit could allow the magistrate to reasonably infer that the information came from the officer's own observation or those of other officers engaged in the investigation. Are you back?
Yeah.
Okay, here, then you can read this page.
All right. Here, defendant's evidence demonstrates there were several law enforcement agencies working together in this case, including the Idaho State Police, the Moscow Police Department, and the Federal Bureau of Investigation. During his testimony from a prior hearing in this matter, Detective Brett Payne from the Moscow Police Department explained that agents from these three agencies were co-located at a command center set up at the Moscow Police Department for purposes of the investigation. Exhibit D4B, which is the May 30th, 2024 hearing, and then gives a transcript, like page and line. These agents were assigned different investigative tasks. Pertinent information they learned in performing those tasks was then exchanged and transmitted into a working probable cause affidavit, i.e. draft exhibit A. I know the information from the draft exhibit A was then incorporated by law enforcement in varying degrees into the exhibit as supporting the search warrant applications. Importantly, the exhibit as challenged by defendant included statements alerting the magistrate that the affiant was assisted by other law enforcement agents and that the information contained within the exhibit A was based on information provided by these other agents. See Blaker's exhibit. Okay, so this makes more sense why we saw the two. You know what I mean?
Mm-hmm.
So exhibit D2 at Bates, I think it's the Bates number. I am being assisted by other officers. This is in quotes. Quote, I am being assisted by other officers of the Moscow Police Department, members of the Idaho State Police, and agents of the FBI. And then, and a quote, as found in Wilson, this is sufficient to allow the reviewing magistrate to reasonably infer that the information within Exhibit A came from not only the affiant's personal knowledge, but the knowledge of other law enforcement investigating the crime. Moreover, given the breadth of information in the affidavit, it is readily apparent that the affiant did not perform all work identified therein on his own. Further, defendant has not cited to a single case supporting the proposition that law enforcement's use of a working probable cause affidavit is improper. In sum, defendant has failed to make the requisite showings under Franks on issue 1. Further, under no circumstances could it be reasonably concluded that had the swearing officer disclosed which members of law enforcement provided which piece of evidence, the magistrate would not have found probable cause.
So, 2, the defendant has not established that alleged misrepresentations in any of the 3 challenged search warrant affidavits compel a Franks hearing. The first misrepresentation identified by defendant in issue 2 is contained in Blaker Exhibit A supporting the warrant application for defendant's Pullman, Washington apartment and his office at Washington State University. We went over that in episode 2, guys. Defendant claims that Sergeant Blaker, quote, attributes discovering the knife sheath to Idaho State police officers rather than Detective Payne. However, as the state correctly notes, the defendant's challenge is nothing more than a quibble over semantics. What Sergeant Blaker stated was, quote, I was later advised by ISP investigators they located a tan leather knife sheath laying on the bed next to Mogen's right side, wind viewed from the door. In fact, it was Detective Payne who was the first investigator to discover the knife sheath. Once discovered, Detective Payne noticed ISP investigators who then collected and booked the sheath into evidence. At best, Sergeant Blaker's use of the word locate is ambiguous as to whether it means discovering or collecting. Under no reasonable reading could it be characterized as misrepresentation, let alone an intentionally or recklessly false one. The second alleged misrepresentations are in Payne Exhibit A supporting defendant's arrest warrant application and Mowry Exhibit A supporting the Google warrant application. Exhibits D3, B, D3A, respectively. Defendant claims that both detectives simultaneously claim to have done cell site location information work, as well as work to determine whether defendant's cell phone was in the area of the King Road residence. Defendant notes, however, that both detectives admitted at a subsequent hearing in this matter that it was actually the FBI cast agent Nicholas Balance who performed the location work that the detectives then used to complete their respective affidavits. The agent Ballas was the individual who actually did the location work does not render the detective's statements intentionally or recklessly false or even misleading. And so those exhibits show that Bryan Kohberger's phone was utilizing cell resources that provide coverage to the area of the King Road house on at least 12 occasions prior to November 13th. All of these occasions, except for one, occurred in the late evening and early morning hours of their respective days. So if you want to start the next page, but it starts while.
Okay. While defendant asserts that the detectives both claim to have done the work, they do not. They state that they were able to determine the locations after consulting with FBI CAST. Both detectives explained in their respective affidavits that CAST was the FBI's cellular analysis survey team. Thus, it was made abundantly apparent to the magistrate that the detectives were relying on work performed by more specialized law enforcement agents in determining the cell phone locations. In sum, as to the statements encompassed in issue 2, defendant has not established that a misrepresentation was made. Moreover, even if the challenged statements could possibly be construed as false, there is not a shred of evidence they were intentionally or recklessly false. Finally, even if the statements were intentionally or recklessly included, defendant has not established they were necessary to establish probable cause. In a common and massive investigation such as this, which specific member which specific member of law enforcement actually discovered the knife sheath or performed the location work using CSLI is irrelevant to probable cause. What is important is that the information came from other law enforcement personnel, which is a reliable basis for the warrant. Consequently, a Frank's hearing is not warranted on this issue.
Okay. And so just for anybody who's like, okay, what does that all mean? If you guys remember when you're reading the transcript and we had our first witness up on the stand and it was Detective Brett Payne. And if you don't recall, Brett Payne's point of view was written in the affidavit for the PCA to obtain the first initial search warrants of Bryan Kohberger. They're arguing that, well, hey, when Brett Payne signed off on that affidavit, it was in Brett Payne own, like it was his work that it was done, but it wasn't just his work that it was done. It was collectively work that was done, and other people testified that that was their work. But the Judge Hippler's like, no, okay, because you're picking and choosing words in the PCA, and if you go back and actually quote them, it's not exactly what they said. And of course, there's going to be reasonable doubt that there's going to be reasonable room given that it's collective work that's done as law enforcement, as detectives. It's not literally just you versus we're working as a team and we're putting this together to build the probable cause.
Mm-hmm. And Sin just gifted memberships.
Oh, Sin, thank you. Welcome to our new members. Please make sure you thank Sin. That's very kind of you, very generous. Welcome. I'm so excited for this next part.
Okay,
Sorry.
I'm gonna read. I know you are, so I'm just gonna read this one part that goes underneath it. So, as at the very end when they said a Frank's hearing is not warranted on the issue, Cliff note is defendant makes a cursory allegation with issue 2 regarding an email agent balance sent to Detective Payne identifying the dates and times of prior occasions. The defendant's cell phone was using cellular resources consistent with it being in the area of 1122 King Road. And lists the exhibit number. Defendant contends the dates in the email were different than those in Agent Balance's CAST report. Defendant has not identified a search warrant affidavit that included these allegedly inconsistent dates. Thus, to the extent defendant is claiming the dates in the email were false, Franks is not implicated.
Oh, that's absolutely amazing. Stephanie says the missing girl from tonight was found safe. Thank you so much for that update.
Hey,
I love that. 2 nights in a row.
Me too.
Okay. So I know.
Y'all ready? This is big, guys. This is going to get into Dylan.
All right. B. Defendant has not met his Frank's burden on issues 3, 10, eyewitness statements. So in issues 3 and 10, Kohberger challenges that probable cause statements insofar as they set forth witness Dylan's interview descriptions of things she heard and saw on the night of November 13th, 2022. Kohberger claims that law enforcement failed to inform the magistrate that Dylan's accounts describing the suspect were variable, that she questioned her memory, and that she did not recognize Kohberger when provided with a photo of him after his arrest. Kohberger also contends that law enforcement misrepresented statements made by Dylan that would have demonstrated her unreliability. Those allegedly false statements and omissions, according to Kohberger, were exculpatory and material. So it says omissions regarding Dylan's reliability and consistency. It applies to all warrants insofar as it pertains to her non-recognition of Kohberger. It applies to warrants issued after December 30th. And Dylan was a roommate of the deceased and was in her own bedroom at the time of the homicides. So while I'm saying Kohberger to try to make it easier for anyone just listening. So while Kohberger's challenge may be fodder for cross-examination, it is not the proper subject of a Frank's motion. Kohberger's own proffer establishes that Dylan's accounts were remarkably consistent throughout her multiple interviews with law enforcement. And further, the probable cause affidavits are very consistent with her accounts. Second, Dylan's interview statements that her memories were fuzzy and dreamlike and may have been affected by being tired or under the influence of alcohol do not call into question her reliability to the extent of Frank's would require disclosure. Finally, Dylan's failure to recognize the photo of Kohberger is of no consequence given that the intruder she saw was masked. 1. Dylan's accounts were consistent and accurately summarized in the Exhibit A's. The draft Exhibit A circulated by law enforcement included the following description statements Dylan made during her interviews with law enforcement. I'm so excited. Dylan made statements during interview that indicated the occupants of the King Road residence were at home by 2 a.m. and reportedly asleep by approximately 4 a.m. This is with the exception of Kernodle, who received a DoorDash order at the residence at approximately 4 a.m. Dylan stated she was awoken at approximately 4 a.m. by what she stated sounded like Kaylee playing with her dog in one of the upstairs bedrooms, which were located on the 3rd floor. A short time later, Dylan said she heard who she thought was Kaylee say something to the effect of, "There's someone here." A review of forensic records associated with a download of Xana's cellular phone indicated she was likely awake and using the TikTok app at approximately 4:12 a.m. Dylan stated she looked out of her bedroom, but did not see anything when she heard the comment about someone being in the house. Dylan stated she opened her door a second time when she heard what she thought was crying coming from Xana's room. Dylan then said she heard a male voice say something to the effect of, quote, "It's okay, I'm going to help you." At approximately 4:17 a.m., a camera at 1112 King Road picked up audio of what sounded like a struggle coming from off camera. The security camera is less than 50 feet from Xana's bedroom wall. The struggle lasted less than 1 minute and unintelligible sounds can be heard on camera. Okay, so you could start into the next one.
Okay, Dylan stated she opened the door for the 3rd time. Is that right?
Yeah.
Okay. Dylan stated she opened the door for the 3rd time after she heard the crying and saw a figure clad in black clothing and mask that covered the person's mouth and nose walking towards her. Dylan described the figure as 5'10" or taller, male, not very muscular, but athletically built with bushy eyebrows. The male walked past Dylan as she stood in a frozen shock phase. As the male walked towards the back sliding glass door, Dylan locked herself in the room after seeing the male. Exhibit D1C, pages 7 through 8. This portion of the draft Exhibit A was incorporated in varying degrees into Blaker's Exhibit A, Payne's Exhibit, and Mowry's Exhibit. When these Exhibit A's were submitted in support of search warrant applications, Dillon had sat for at least 3 interviews with law enforcement, 2 on November 13th, 2022, 1 with Officer Nunez, and later with Detective Mowry, and 1 on November 17th of 2022 with Detective Gooch. Her description of the intruder was notably similar during all 3 interviews. 1, white male. 2, slim, skinny, lean body type. 3, slightly taller than Dillon, 5'10". 4, wearing all black. 5, wearing a mask that was covering his forehead and mouth. 6, a voice she didn't recognize saying he was here to help. Okay, so that pretty much takes away people thinking it was Ethan.
Mm-hmm.
And 7, the intruder walked out or towards the back sliding door without saying anything to her. While she did not tell Officer Nunez that she noticed the intruder carrying a vacuum type object in his hand.
The fuck?
Oh, I know Truth Exposed is already in chat. Like, so okay, if you look at like, so you know how like they have like how you can add like the vacuum attachments, like to like so if you look at the shape of it, it could look like a shape of a knife. That's what some people are speculating. Like if you look at Truth's, is a K-bar in the bag she saw, not a vacuum. She thought it was a vacuum. I don't know. I mean,
Okay.
I'm interested.
Yeah.
So, the intruder walked out or towards the back sliding door without anything to say to her. Okay, blah, blah, blah.
And that's what I was going to say too, but I didn't want to jump the gun. He didn't say anything towards her, to her, meaning he saw her. Hello? If he didn't see her, Shay, why would she say he didn't say anything to me? He didn't see me. He saw her.
I don't know. We don't know if he saw her or not. I don't know.
You know, that's been my theory from the beginning.
But we really don't know. I don't know.
I can't take that as a little nudge more towards he saw her. I definitely, clearly Harlot did too. That's how I took it.
Oh, Lordy. Okay. I hope you're not taking notes because you'll just like use the whole document. Anyways, I'm just kidding.
No, not for this because there's too much. I'm going to remember this.
Okay, so 7, the intruder walked out towards the door, so didn't say anything to her. While she did not tell Officer Nunez that she noticed the intruder carrying a vacuum type object in his hand, she did convey that information to Detective Mowry later that day, as well as Detective Gooch a few days after. She also told Detective Gooch that she remembered the suspect's eyebrows were bushy, but could not remember their color. And then DM likewise told Detective Mowry she could not remember the color of his eyebrows. More importantly, not only are Dillon's statements with each other with regard to the intruder's description, they were accurately included by law enforcement in the Exhibit A's set forth above. There is not one statement in the affidavits regarding the intruder that cannot be traced directly to Dillon's words. Consequently, defendant has not demonstrated an intentional or reckless false statement or omission of a material exculpatory fact with regard to law enforcement's recounting of Dillon's description of the suspect.
So I need to pause. I need to go back here though, because okay. Dillon heard a voice she didn't recognize that said he was here to help. The intruder walked out or towards the back sliding door without saying anything to her, which I really take as he saw her, but he didn't say a fucking word to her. And while she did not tell officers that she noticed the intruder carrying a vacuum type object in his hand, she did convey that information later that day. So he was holding something. Now, why she would think it's a vacuum type object, and thank you, Brady, most I miss you. Oh, thank you. Unless, like, again, that's her brain in trauma, in in an altered state, trying her best to put together something she's seeing, and it may have been that knife, because it's not a vacuum type object or a vacuum like extension type object, like not the vacuum itself but an extension itself.
Yeah, but then I also go back to remember he had that thistle power or whatever thing that was taken from his apartment.
I cannot believe he walked in with a fucking vacuum. Jay, don't do that to me. Don't do that to me. Like, there's just no fucking way. That's too far for me.
I'm kind of in more of like, maybe she's describing the shape of something. Like,
yeah, like I could believe he put the K-bar in something, maybe, and that's also.
But the sheath, the sheath is missing. Like,
yeah, I don't know. I'm gonna have to ponder on this for a fucking minute here.
But what if it? Okay, so Truth, are you saying you think it's a bag? Because I'm also one that I really believe Truth had a theory on, everybody's like, oh, he would have cut himself. And Truth Exposed and Chat had a theory a while ago, and I think there's merit to it that like butchers, they have gloves that that you can put on that can't be permeated and cut through. So what if he had something like that on his hands, but then if it's a bag, like what if it is a bag? What if he thinks the sheath is in a bag? I don't know. This is interesting. I don't know.
I don't know.
I don't think she thought that he was like an intruder at the time.
I don't think her brain could process, and I believe that. It was only this morning when I woke up, and I got very confused when I woke up. I was in one of those states of, did I miss work? Did I, like, where am I? Like, it was one of those moments, like, and so I could believe in the moment her brain didn't register, but for her to say a vacuum type object, it may have been the way he was holding. Like, I could believe he brought maybe a bag to put the whatever in as he leaves, and the way he was holding it. You know how we hold vacuums? At least I hold it. You kind of hold it up in front of you, like with the one hand. Maybe it was the way he was holding it, and the outside was darker, and her brain really couldn't register what she was seeing.
Yeah, I don't know. My mind's blown by that one. I don't know. So trying to see what the chat is saying too. I like to hear what are y'all's thoughts?
Tess says, I think he had a Tyvek suit with those waterproof carrying bags with the knife sticking out, so it looked like the hose of a vacuum. It's never a mannequin. He was in trance, had to get out. I don't understand Dylan's movements. She saw an intruder, didn't contact the police until the next morning after contacting her friends. That's the biggest issue I have, is I'd like to know, was she locked in and never went back to sleep? Was she awake? We do know that there were messaging. I think she got so freaked out after what she saw that she wasn't willing to leave her room, but why she didn't call the police versus summoning friends so much time later is the biggest issue for me. But I'm going to reserve and wait to hear what comes out. Yes, he does have a burglary charge, but that's breaking in. The breaking in.
Yeah, I guess I'm just kind of I'm thinking, See, I don't think I think that I don't like okay, really, if you like wake up in the middle of the night and you've been drinking and you have a house that tends to, be active and you have other roommates, like I don't think your first thought is like an intruder is here,
Yeah. But that's why I'm saying first hour, I could believe flew by. Anything in that state of mind, like time gets tricky. But the amount of time that passed and not nobody's answering. Maybe just maybe just Bethany's answering. If you locked yourself in and you won't even come out still, that's a lot of time to pass.
Yeah.
Oh, I don't know about that, Stephanie.
About what?
I think Dylan and Bryan were involved with each other, and she knows a lot more than she's saying.
Oh, I mean, they would have already investigated that and any correlations. I mean, I mean, from what we know, I think that the defense is saying that he has no connection to anyone in that house.
As far as we're understanding right now.
Yeah, that's just a kind of a general understanding.
Yeah, Tara, that's the biggest issue I'm having at this point, is not even that some time passed, but law enforcement wasn't contacted first, and the amount of time passed.
Right.
So it says Kohberger also asserts that Exhibit A watered down Dylan's statements about hearing Kaylee around the time of the homicides. According to Kohberger, Dylan was unequivocal in her 3 interviews when she reported that at approximately 4 a.m., she heard Kaylee walk upstairs with her dog before running back down the stairs saying, "Someone's here." In Draft Exhibit A, however, law enforcement represents that Dylan said she heard who she thought was Kaylee say something to the effect of, "There's someone here," emphasis added. Kohberger argues the addition of the word thought is false, and further, Kohberger surmises it was intentionally false to cover up the fact that Dylan was wrong about what she heard. Kohberger points out that Kaylee was killed in the upstairs bedroom where she was found the next morning. Thus, it could not have been her who Dylan heard running down the stairs at 4 a.m. Kohberger contends that Dylan's misperception, had it not been covered up by law enforcement, would have cast doubt on her reliability and therefore probable cause. However, the statement challenged by Kohberger could be read in 2 ways. One, that Dylan said, "I think it was Miss Goncalves," which is how Kohberger apparently reads it, and which he claims is inconsistent with Dylan's interview statements. Or 2, that Dylan said she heard Miss Goncalves, but law enforcement had reason to think it could have been someone else. When the statement is viewed in context, the latter makes more sense. In their respective Exhibit A's, Detective Payne and Sergeant Blaker immediately followed up the challenge statement with the following, quote, "A review of records obtained from a forensic download of Xana's phone showed this could also have been Xana, as her cellular phone indicated she was likely awake and using the TikTok app at approximately 4:12 a.m. Payne's Exhibit A at Bates 5161, Blaker's A, and Bates 5200. Through this explanation, Payne and Blaker are effectively conveying to the magistrate why they believe Dylan's statement of who she heard was questionable. Thus, the court cannot conclude that there is anything false or misleading in this regard. And I don't disagree with that. I don't think it would have, I don't think it would hurt her credibility, because again, when she was hearing those noises, and this was a party house, her brain would have assumed and put together what she believed she was hearing. So at the time, I do expect her to be like, I heard what I thought was Kaylee and the dog playing, because that's what would have made sense to her with what she was hearing prior to ever seeing anybody in the house that wasn't supposed to be there.
Okay, so I just got to go back to this because, like, I have a little bit of a theory. Okay, so they have, I think there's like a crime, like a crime kind of house type of something that they offer. I can't remember exactly what it's called at WSU for investigative purposes for like criminology students. What if the university had like one of those NVACs that they use for evidence, and what if he used it? What if he borrowed it to go with him?
Shay, I'm telling you right
It
now,
looks like a little, like those little handheld ones. Have you
I
seen
know
those?
what you're saying, but I, for the life of me,
Sorry.
cannot incorporate an effing vacuum into this mix. Already already we are dealing with such a short time frame, and maybe if we had some more time, and I would still be struggling with bringing in a vacuum, but with the time frame we're talking about, no, I cannot handle a damn vacuum. I see what you're saying. I understand what you're saying.
You rebuke my
But
vacuum right now?
no effing way. Just no. I'm relying on the fact that Dylan shot that out there, but in a state of mind where, again, everything else implies that her brain was putting together what she thought was making sense. And in that moment, I don't think she visibly saw really a description of anything other than what her brain perceived, and probably the way he was holding it. And when I hold the vacuum and I move the vacuum, I hold it by its handle up in the air, kind of in front of me. I think he may have been holding something which, for whatever in her mind, in the mid-sleep alcohol state, she's like, I don't know, like a vacuum looking type thing, based on how he held it. Not that he brought a fucking vacuum in with him.
Okay.
I'm sorry, I can't.
And now, like, truth is dragging me. Okay, but what if it doesn't make noise? I don't know.
Yeah, and I was about to say, also, when did we hear free? You know, like, come on, did he find an outlet?
But you know, according to his downstairs neighbor, he likes to vacuum.
You know what? That's true. That's true, but don't throw my mind for a fucking loop right now. I can't. Not the vacuum, man. Oh my god.
And what's gonna happen if it actually is a vacuum?
Yo, I'm done. I'm walking away, okay? Yeah. No way.
You leave your sheath, but you take your vacuum.
Yeah, I'm shutting my notebook right now. Ain't no way he brought a damn vacuum with him. I'm telling you.
Oh my god.
Right, and that's how I took it. She was describing things familiar to her. Her brain wasn't assuming a huge knife, possibly with another object. Who knows if he already started to take off, if he was wearing like a coverall type thing. Who knows? But he did not stop to vacuum. Come the fuck on.
Okay, but I'm thinking as a 19-year-old, if I'm saying, well, at the time I thought it looked like it was shaped like an attachment to a vacuum. Like, you really think that's where their mind goes?
I think she was in a trauma state mind, alcohol, and her brain didn't know what the fuck she saw. And just based off how he was holding it, I think about it. How many objects do you hold like that, which tells me it had to be hanging below his hand? That interests me. It wasn't above his hand. If he was holding it out in front of him, it would have been.
Why would you hold it out in front of you? You would hold it to your side when you walk. That's how you hold a knife.
Not if he was trying to keep the DNA away, like get it away from his body. You think it's easier to think vacuum than it is to hold it in front of you?
I mean, hell, this vacuum thing, it probably gave credence to all those that think that there was this huge cleanup in Pablo Escobar's drug tunnels underneath there, and all this shit's happening, and you pop up in a dumpster on Linda Lane. I mean, who knows, man?
I think he was holding, maybe he brought a bag with him or something, and he was holding it out in front of him, not to trail anything more on him, not to have him on it.
No, why would you do that? Just put the knife in something. Like, why would you want to, like,
in a bag or something?
And what about the damn sheath? Like, when does mine go? Where's my sheath? Like,
no, not in that state of mind, because I don't think Xana and Ethan were planned.
Okay.
And the vacuum didn't even come about till the second interview that day, which tells me it wasn't something in the forefront of her mind. It was something that came more after their questioning. And how would you describe it? I don't know, like a vacuum type thing. It didn't take the forefront, or else it would have come out during the first interview.
Okay. Let's give it that. What if the question is, did you see him carrying anything? What was it shaped like? Okay, if she uses the vacuum a lot and knows what that attachment is, then all for it.
Well, okay. He was walking towards her. She saw him turn towards there, but she didn't watch him actually leave. So how long did she even get to see this object? Because she's also looking at his face. able to see these eyebrows. You know what I mean? So
Yeah.
did she even look at the object, or did she see a shadow of what she thought? And she really didn't even, so from a fucking shadow or so much is happening in her mind right then. This is the third time she's going through the door. She's hearing these noises. Now she hears what sounds like Xana crying. Okay. In this split
And then he
second.
walks out and with something carrying a bag. Okay.
Well, I don't even know if she was able to visually look at his hand versus she seeing him, and as he would have been walking towards her. Do you think her eye would have went towards his hand, or do you think she was staring more at him and then he moved, and like in the peripheral vision she notices he was carrying something, and for whatever reason in that moment it seemed like maybe a vacuum? All it tells me is it's something that was hanging lower. It's something that was hanging lower.
And I think dark too, because the K-bar is a darker color blade from what I remember.
I think he was carrying something outside of just the knife. I think he was carrying something that hung down.
Like a bag?
I don't know. All right, let's see what else. Go ahead. We're on page 13.
Sorry.
No, I'm just mind blown right now, but let's see what else they give us.
You're like a fucking vacuum? I'm like, I mean,
I
hey.
can't because listen, Shay, we had to do so much debunking. Okay, back in the day. And if I have to incorporate a vacuum, it's too much. It's too much. I can't handle it.
But before I murder, let me grab my Bissell.
Imagine if she meant he was carrying a full upright vacuum. I can't do that. Or maybe you know what? Let's lighten it down a little bit. Maybe
Thank you, Harley. That's what I said. You hold it down.
But hey, all right. So let's kind of like rid the whole vacuum Bissell type out of our mind versus one of those smaller handheld.
That's what I said. That's what I said.
I know. But now I'm trying to like reposition in my mind what I was thinking.
What if he brought it just because he was like he had this plan? What if he's like, in case something happens, I can like do the evidence here.
Jay, I said, let me incorporate this as an object shape, not the fact that he would have it. Versus that's what her mind perceives.
Are you telling me to calm my tits here and just let this be?
I can't. My brain, it's struggling. It's struggling here. Oh man. Like I can't. I just really can't believe he would bring in a vacuum. I really could not do that.
I would love for that to happen just to like see your reaction.
I'm done. If that comes out in trial, I'm walking away, man. I can't.
All right. I'll keep reading. In addition, even assuming it was a false statement, defendant has not established that it was an intentional or reckless attempt to hide Dylan's alleged misperception, or that her actual statement was exculpatory or otherwise material to probable cause. Consequently, a Frank's hearing is not warranted with regards to statements in the relevant Exhibit A's as regarding DM's account of what she saw and heard. And what was that? Cliff Note was 20. So that says, based on defendant's proffer, it is not a foregone fact that Dylan was mistaken when she said she heard Kaylee. Dylan reported it was approximately 4 a.m. when she heard Kaylee walk upstairs and then run back down the stairs saying someone's here. Miss Xana received the DoorDash delivery at the residence at 4 a.m. It is entirely possible Kaylee ran downstairs when she heard the delivery person and then went to bed after which she was killed.
Wow. Okay.
That's interesting.
It is interesting. So we're dealing with a very tight timeline.
And yeah, now we're gonna get into like I think this is where it gets more specific because I haven't read this, but I heard that like the judge really offers some stuff. So okay.
Mm-hmm.
2, there is no evidence law enforcement intentionally or recklessly omitted information bearing on Dylan's reliability, or that such omissions were material to probable cause. Kohberger next asserts that The probable cause statements omitted important information bearing on Dylan's reliability. Kohberger notes that Dylan qualified her interview statements on several occasions by questioning her memory of the event. For example, she told Detective Mowry, quote, everything was kind of blurry. Like, I don't fully remember it, I would say, unquote. A few days later, while recounting the events to Detective Gooch, Dylan said, again, I believe I was also very drunk. I don't know how much of this is real. Like, I don't know if my mind was like doing whatever. I don't know any of it. Like, half this stuff, I don't know if it's a dream or if it's real. I just have no clue. She also said her memory was, quote, fuzzy and cloudy, unquote, and she could not, quote, differentiate if anything is real or if anything is a dream, unquote. This information was not included in the Exhibit A's. According to the defendant, this information was crucial to allow the magistrate to properly evaluate Dylan's reliability, and its omission was material and exculpatory. The law does not favor Kohberger on this argument. Probable cause is determined by examining the totality of the circumstances and making practical common sense decision whether giving all the circumstances set forth in the affidavit before the court, including the veracity and the basis of knowledge of persons supplying hearsay information. There is a fair probability in contraband or evidence of a crime will be found in a particular place.
Okay, so hold on. So again, Xana received a DoorDash delivery at the residence at 4 a.m. It is entirely possible Kaylee ran downstairs when she heard the delivery person and then went to bed. So the delivery, I'm trying to see. Did they?
So
do we know if Xana got it? Do we know if Xana retrieved it?
I think what is being implied here by the judge is saying too that, like, we don't know for sure if it wasn't Kaylee
Right.
saying that.
But
So
also it kind of implies it doesn't say. But I gather, because I know Judge Hippler is being very careful with what he writes too. It makes it seem like Kaylee came when the delivery person came to the door. At least we still don't know if it was drop off or hand-to-hand delivery. We don't know. But
right.
it would imply Xana received it. I can't jump that. Let me be clear. We do not know that. But yeah, that's how I take it too, King Scarlet. I would take it as she would have been told what the fuck happened, right? And her brain would have been like, I don't even know. Like everything is a fucking blur. And I would believe that. That's not what I have an issue with right now. I really don't.
And hey, King, good to see you, girl.
So whether the hearsay supplier is reliable is dependent in part on their status. Unlike an informer from the criminal milieu, crime victims or witnesses are presumed reliable and may be relied upon without independent corroboration. Despite this presumed reliability, police must always be alert to whether other facts which have come to their attention raise doubts about the veracity of the witness. Such facts might include a motive to exaggerate or falsify statements made to law enforcement, and when the hearsay supplier is a young child or suffers from psychological delusions. In such circumstances, corroboration is required to establish reliability. However, this is not a burdensome requirement. The corroboration of even innocent minor details can support a finding of probable cause. Any omissions of facts bearing on an individual's reliability will only be considered misleading under Franks if the omitted facts cause doubt on probable cause. So, misrepresentations or omissions that could impact the credibility assessment of a witness do not trigger a Franks motion where probable cause is nevertheless established through other evidence. None of Dylan's qualifications during her interviews reasonably placed her presumed reliability in dispute. She was a direct witness and was able to consistently articulate the details she remembered throughout each interview, especially as to the facts relied on in the search warrant affidavits, despite the fact that she claimed her memory was fuzzy, or that she felt like it was a dream, or that she was still intoxicated. Further, even if her reliability were in question, there were other evidence included in the Exhibit A's that corroborated her account. So hold on, let me jump up. So this is just, okay. Although officer failed to include in the search warrant,
That's
that
just
the
citing
juvenile
states.
informant had lied to the officer. Oh, okay. All right. So then, go ahead.
Furthermore, even if her reliability were in question, there was other evidence included in the Exhibit A's that corroborated her account. For example, the security camera from 1112 King Road picked up audio of a struggle at 4:17 a.m., which coincides with when Dylan stated she thought was crying coming from Xana's room and a male voice speaking. Because we remember in the PCA, we just hear it's called a thud.
Yep. Now we know
Okay.
it lasted about a minute. A struggle that lasted about a minute.
Which coincides with when Dylan stated that she thought that she thought was crying coming from Xana's room and a male voice speaking. It was shortly after this she opened the door for a third time and saw the suspect walk by her toward the sliding glass door, which corresponds with the surveillance video showing the suspect vehicle leaving 1122 King Road at 4:20 a.m. They got him on camera. Okay. In addition, law enforcement corroborated Dylan's description of Kohberger through its vehicle identification efforts, which led investigators to Kohberger's driver's license information. The Exhibit A's note that Kohberger's physical description was consistent with Dylan's account. Defendant has shown no objective indication that Dylan's interview statements were unreliable, particularly given the other corroborating evidence, and therefore no reason for law enforcement to include her qualifications in the affidavit. For this reason, it cannot be said that law enforcement intentionally or recklessly omitted the information. Furthermore, the Exhibit A's inferred that Dylan was traumatized when they noted she stood in a frozen shock face when she saw the intruder. This necessarily alerted the magistrate that Dylan's memories were colored by trauma and shock, which goes to the issue of her reliability that Kohberger Kohberger targets in this motion. Finally, even had even had the Exhibit A's included Dylan's qualifications to her memory, it would not have significantly undermined her credibility and would have not negated probable cause. It would be no surprise to the magistrate that a person experiencing what Dylan must have experienced would be shaken by what happened and would have questioned the reality of what she perceived. This does not render her unreliable. Additionally, the bulk of probable cause came from other sources, including the extensive vehicle identification efforts. Thus, even if the magistrate questioned the reliability of Dylan's account, she had sufficient grounds through other evidence to issue the warrants. In sum, Kohberger has not shown that Dylan's various qualifications to her memory are material, exculpatory facts that were intentionally or recklessly omitted and that would have been affected probable cause. It is evident from the applicable Exhibit A's that Dylan's account was largely relied upon to establish the timing of the homicides and a general description of the perpetrator, not to identify Kohberger specifically. Her statements on these matters were consistent. While any perceived weakness in her memory may be fodder for cross-examination, they do not negate probable cause. Consequently, a Frank's hearing is not warranted.
So, thought.
Hmm.
What if whatever he may have been holding, he didn't have going in, but there was a reason he took it out with him?
That too. I thought, what if he had to use something, like, use something, I don't know, I don't know. What if he,
No,
what if he,
that's not true at all, Sue Jones. Well, and I'm not saying he's on the spectrum, but not every person on the spectrum responds with explosive anger. That's not accurate. And I don't like to put every person who is on the spectrum labeled in a box. Yes, there are certain traits and tendencies, but no, they don't all respond the same way at all in situations, respectfully. But yeah, what if he had something he took out with him for a very specific reason.
Right, Christina. That's what I was saying. Like, even if, say, he is on the spectrum, he was going to school as a PhD criminology student. He's obviously interested in the law. He would, in my opinion, this is my opinion, be able to determine right from wrong. But regardless, like, there are other people that are on the spectrum that have been convicted for crimes as such, but the way that they are sentenced is handled differently and by other Supreme Court law.
Well, and one can argue someone on the spectrum would be more capable of getting away with the crime because they are brilliant. The way their brain works, everyone usually highlights that it works differently in the aspect of, it's not like, someone who's not on the spectrum, almost in I don't want to say in a bad way, but right, it works differently. They're brilliant. Like their brain works differently in so many amazing ways. And so things that someone not on the spectrum wouldn't normally think of, someone on the spectrum would. And when I say that, I'm not saying being on the spectrum would have you committing the crime, versus if we're going to make the argument that, if you were on the spectrum, you couldn't commit a crime like this. Actually, I would think someone on the spectrum would be much more capable when it came to getting away with it than I would someone off the spectrum.
Right. I think the issue at hand is for where a person would be on the spectrum to be able to determine the right or wrong. That is really what the issue would be for somebody. Okay.
Right.
Anyway, do you want me to do this one or you want to do it?
No, I'm good. So it says DM's non-recognition of defendant is immaterial. So Kohberger also contends that law enforcement's failure to include Dylan's non-recognition of defendant Kohberger in the Exhibit A's warrants a Frank's hearing. During her December 30th, 2022 interview with law enforcement, Dylan was shown Kohberger's mugshot and asked by Detective Lake whether Kohberger was the person she saw in her house. Dylan responded, "I have no clue. From what I remember, I just remember seeing this figure that was more of like the skinnier tone build and some mask on. I don't know if it was covering his mouth, his nose, or below his mouth and nose. I just remember he was white, but I didn't know how he was white. I just knew he was. And I knew he looked at me because of the bushy eyebrows." Boom! Sorry. He saw her. I freaking knew he saw her.
And now you're wondering why she was spared?
No, I know why. This has been my theory.
Why do you think that she was not?
Because Ethan and Xana, and this is just my working theory, guys, and Ethan and Xana were not planned. We were just arguing how your perception of time is completely off in these situations. I think being that this was a high adrenaline situation, Ethan and Xana were not planned. We know that noises were being picked up. Dylan's leaving out of Dylan's
the
open. I don't know if
the dog's barking. Remember?
The dog's barking nonstop. The dog barked 25 minutes past when allegedly Kohberger left. I don't know if he ever once heard Dylan open and shutting those doors. All he knows at that point, in my working theory, is that there is noise. The dog is barking. How much time has passed? He wouldn't have. You just took 4 lives. At that point, I believe he would have assumed police were already on the way. There's a good chance police were on the way, and he needed to get out. That is why he was willing to leave her behind. That is why he came back the next morning, because he couldn't for the life of him figure out, why haven't I gotten an alert yet? Why isn't it on the news? Why isn't the radio? And curiosity took the best of him, and he had to do a quick drive-by, and he did. He did a quick drive-by, and nothing was going on.
I don't know. I'm kind of neat. Like, I don't know if it definitively says he saw her.
What?
Like, that's an interpretation. Just because you can see somebody's bushy eyebrows without them looking. But what about his little snow vision thing? That he's written about in
screw
Visual
that.
snow.
He looked at Dylan. He looked at her. I'm with me on this one. He looked at her. Now, I don't know whether or not he looked at her with a vacuum in the hand, but he looked at her. Yep, that's what I think, Carlet. Yeah, the dog was barking. I do not believe Xana and Ethan, as of yet, were planned. So do you know what it's like to go in? And he may have only intended to kill one. Kaylee wasn't supposed to be there. Who knows? And then you're walking out and four, how much time is passing? That dog has been barking since the first, when he went upstairs. That's my theory. He went upstairs. That dog is barking. Who knows if he heard Dylan's door closing and shutting? He needs to get out now, because if he takes the time to then take care of Dylan, there's a good chance he's going to be caught in the act, but she didn't.
I know. And guys, just so you know, just because I'm saying things that may be opposing, it doesn't mean that like I don't not agree with what Melissa says or interprets. I want to like think through all possibilities.
You need all sides.
So okay, reference Bundy. I mean, you know, he left other surviving people in the sorority house. Like, there are times that happens. I do get that. So was it that like he knew he had a run time to get out of there, and it was like, time's up, dude, I gotta get go?
Yeah, I think he
or
was.
or maybe what if he thought she called the cops?
I think he perceived that the cops were already most likely on the way.
Yeah, and he had to get the hell out of there. I could believe that. I could definitely believe that.
I've been saying that 2 years ago. Oh my God. I knew he saw, because when I think about, okay, yes, they were living in a common house, but so I imagine the common rooms. I don't know whose job it was to kind of like, I know in my place, right, I shut down all the lights. I don't know whose job it was to shut down the common lights, but I do believe if everyone was in their rooms and sleeping, most likely that here, let me do this. Most likely the common areas lights were off. Okay.
Do you want that thing again?
I have it. No, I have it. I got it. Thank you.
I figured. I know you're going for it.
Yes. Well, because just I'm a visual person. So, okay. If this common area, no, I'm upstairs. Hold on. Let me go back down. Okay. So if this is Xana's room. Okay. So in my theory, he goes upstairs first and he goes downstairs. And I believe him and Xana cross paths. And Xana runs back to her room. That is why she is on the floor. And then you had Ethan, who was at the time at least sleeping in the bed. So I imagine this room, the lights are off. I imagine the kitchen, the lights are off. And it's only their individual rooms that would have some type of light on. I believe Dylan's room most likely had a light of some sort, whether it's a laptop, a nightlight, phone, some type of source. So when allegedly Bryan is walking through, and he is right here, when that door is open, and I'm assuming there's no light on here. Not only is she there and the door is opening, but it would illuminate behind her from a source of light. And I believe that 100% would have drawn his attention, because then you'll see a figure in the light. You see what I'm saying? So it's more of a double reason for his eye to be drawn. It's directly in his path.
Can we put it on dark mode?
I don't know why this one isn't letting me.
It won't let you do it anymore?
Like, well, the one that
Don't you have to like turn the lights like on and off, or isn't it like a light switch thing somewhere?
It used to be. I don't know. This one that I have isn't doing it.
Yeah, that's the same link. I mean, I don't know what happened. Maybe you have to do it from a certain spot. Wait, wait, hold on.
It's not even letting me do the floor thing.
Yeah, like, where's your thing? Here, let me grab it for you. 1 second. I know, I got it. Because we did it the other time. You know what I mean?
Hi, Coffee and Skeleton. Whoops. Oh, well, now I just lost it completely. Okay.
Oh, wait, here it is. Try this one. Grab it. 1 second. What are you doing? Why is it not working? Come on, Safari.
Yeah, growing up Oreo, but you have to also remember, defense didn't even argue it. And even if it wasn't torn down, the jury would not be able to go to the inside of this house. They would only be able to go to the outside. It was not, you're not allowed to go in there with how, I forgot what word it is, with all of the, it's toxic. It was toxic. Yep, the shoe print by her door, King Scarlet. Yeah, you're right. Why isn't it letting me move?
Mm-hmm. I'm trying to get this one to pull up, but okay, try
Biohazard.
this.
Thank you.
I'm gonna put it in back chat. Try this link. I don't know why it's not liking Safari because it's on the iPad. Seriously? Paste.
Yeah, this is the right one.
Okay.
Thank you.
You're welcome. That other one I know it opens up to
Oh.
refresh.
Give me a refresh. What the fudge?
Who messed with it?
Who messed with it? Your new tour sucks.
Okay, why don't you just Google 1122
That's what I did.
King Road Virtual, and then this one for Orbit pops up. Maybe because the way I'm sharing it, it's not working. I remember it having some issues before, but I like the one where you can do the dark. Maybe we're just being obsessive right now.
No.
I want to stare into the dark.
No, it's not. Oh. Why did they take it away? No, see, they only have the Camula again, the one I had on.
Did you type in like tour behind it?
Yeah. And that one, the same thing happened. All right, we'll have to figure out whenever.
Maybe it's, I don't know, maybe just through some updates of browsers that link is just not compatible anymore.
Yeah, because I'm even trying through the Reddits, the old Reddit, whatever.
Yeah.
All right. So
well.
It says, however, the fact that Dylan could not identify Kohberger is hardly exculpatory or material to probable cause. Where am I? Okay. Her interview statements are consistently describing a black-clad, masked person who was not someone she thought she knew or could identify. Her inability to recognize Kohberger unmasked is expected, particularly where her description as related in the Exhibit A's described, quote, a mask that covered the person's mouth and nose. Thus, because her non-recognition is not material and exculpatory, Kohberger cannot demonstrate the failure to include this fact in the probable cause warrant, affidavit warrants, and a Frank's hearing. Defendant has not demonstrated law enforcement omitted it intentionally or recklessly, nor has he shown how including the information would have affected probable cause. One simply cannot say that had law enforcement included a statement that Dylan, unsurprisingly, was able to recognize defendant from a photo, the magistrate would not have found probable cause. A Frank's hearing is not warranted on this issue. Boom. Yeah. All right, you want to read C? Shay Benet. Did it boot her? I can't hear you, Shay. And yeah, I just knew he was. And I knew he looked at me because of the bushy eyebrows, meaning I was able to see those eyebrows because he looked at me. So I'll just keep going. So it says, defendant has not met his Frank's burden on issue 4, vehicle identification. In issue 4, defendant takes issue with Exhibit A insofar as it describes the suspect vehicle captured through various surveillance cameras. It states, law enforcement officers provided video footage of suspect vehicle 1 to vehicle specialists with the Federal Bureau of Investigation that regularly utilize surveillance footage to identify the year, make, and model of an unknown vehicle that is observed by one or more cameras during the commission of a criminal offense. After reviewing the numerous observances of suspect vehicle 1, the vehicle specialists initially believed it needs you to connect your mic and cam, Shay. They initially believed that suspect vehicle 1 was a 2011-2013 Hyundai Elantra. Upon further review, they indicated it could also be a 2011 to 2016 Hyundai Elantra. Hold on, let me type in the back chat, guys, in case you can't hear me. Draft Exhibit A. I don't know what EXH, I guess Exhibit 2, right? Exhibit A, Exhibit D1C. Defendant claims there are 2 material and exculpatory omissions in this paragraph. First, he asserts that law enforcement should have disclosed the FBI's vehicle specialist, quote, felt more comfortable with the 2011-2013 date range for the suspect vehicle. Second, he asserts that the specialist's opinion expanding the date range was, quote, predicated on the erroneous use of a video taken from Ridge Road. There we go. Which law enforcement knew or should have known was not the suspect vehicle. Memo page 14, Kohberger also faults the officers for failing to provide the magistrate with the footage reviewed by the specialist, which, according to defendant, would have demonstrated to the magistrate that a vehicle identification could not have been reasonably made. The court finds defendant's challenges are unsupported by his proffer and do not warrant a Frank's hearing. 1, that the FBI specialist may have been more comfortable with a narrower date range than the represented in Exhibit A is unsupported and immaterial. Defendants claim that the FBI vehicle specialist, quote, felt more comfortable setting the year range of 2011 to 2013 and, quote, law enforcement knew their specialist was of the opinion the car was also certainly between 2011 and 2013 is based on an email chain between that specialist, Agent Anthony Amell, and another FBI agent about their investigation. You want to go, Shay?
Sure.
Just the last sentence going into the next page.
Yeah, and I'm sorry because I had to log out, but did you see Truth's message that she emailed you?
No.
Okay.
I'll check that.
Okay. All right. So, however, the email chain does not support this argument. What the email chain shows is that on November 26, 2022, Agent Amell directed the FBI to open up their search to 2011 to 2016. In doing so, he discussed the changes to the Hyundai Elantra in 2014 and 2017 and stated that he wanted a better shot of the vehicle's front fog lights and rear reflectors. He further added, rather not leave anything out, better safe than sorry. 5 minutes later, he sent another email stating, yeah, I see the change in 2014, and I'm not really a fan of the 214, much prefer the 2011-13, but wanted to lay that out. Have a good night. We'll keep looking and send any new info I can come up with. These emails demonstrate that it was Okay. That it was Agent Emel's decision to open the date range to 2011 to 16, despite his preference for 2011 to 13. Exhibit A accurately captures this decision by stating that the specialist initially believed it was a 2011 to 13, but opened it up to 2011 to 16 upon further review. While Exhibit A did not call out that Agent Emel preferred a narrower time frame, defendant has not shown this omission to be exculpatory immaterial. Exhibit A is replete with evidence linking Kohberger's vehicle and cell phone to suspect vehicle one. Consider as a whole, it could be reasonably concluded that Agent Emel's preference for a narrow date range would have derailed the magistrate's finding of probable cause had it been included. Probable cause is not an exact science and does not require that law enforcement establish with absolute certainty that the facts alleged in the search warrant affidavits are in fact true. Simply because Agent Emel may have felt more comfortable with earlier years within the range he provided does not mean he felt uncomfortable with the later years. Thus, it is highly unlikely the magistrate would have disregarded the specialist identification of the larger date range or otherwise declined to find probable cause simply because Agent Emel preferred the narrower range. Further, there is no evidence the information was intentionally or recklessly omitted. Thus, a Franks hearing is not warranted on the issue. And then it goes on to just state the Elantra's date range. Yeah, I don't really, same thing. So two, got it?
Yeah. Defendant has not demonstrated a false representation or omission with regard to identification of the suspect vehicle. So Kohberger next challenges Exhibit A on grounds that the FBI vehicle specialist identification of suspect vehicle 1 as a 2011 to 2016 Hyundai Elantra was based on video footage from Ridge Road that law enforcement knew or should have known was not suspect vehicle 1. Defendant Kohberger states that he knows law enforcement based its identification of the vehicle on the Ridge Road footage because, quote, we have the emails from the FBI specialist who explains on November 23rd, 2022, that their team is mainly looking at the window configuration, something these other images do not. But later that day, an FBI agent sends them images from this video, calling it a great one. However, Kohberger's proffer does not show the FBI specialist identification was, in fact, made on the Ridge Road footage. The FBI emails Kohberger's content support his position contain no mention of Ridge Road footage and no mention that the FBI was, quote, mainly looking at the window configuration. Kohberger asserts that the email stating, quote, got a great one, attached images from the Ridge Road footage. But there is nothing in the proffer establishing that images were, in fact, attached, and importantly, what those images were. So at the pre-Franks hearing, the court inquired further into Kohberger's support for his position that the identification of suspect vehicle 1 was based on the Ridge Road footage. Counsel again referred to the FBI emails and unlabeled screenshots reproduced on page 17 of Kohberger's amended memorandum that Kohberger's claims were from the Ridge Road footage. This is insufficient to establish beyond speculation, and the Ridge Road footage was the basis for identification. Even assuming it were, however, Kohberger has still failed to carry his burden under Franks because the vehicle identification came from the FBI, which was disclosed to the magistrate in the Exhibit A's. There is a presumption of reliability. So let me see. The FBI emails clearly show that the specialist expanded the date range on November 26, well before Kohberger was identified through IGG in the middle of December 2022.
Well, that's good.
Yeah. Ooh, this is good. Okay.
That's good.
So go for it.
I
think it
what
starts
am I on?
first.
Sorry, I was doing that one above it. So the observations one, a fellow
Page
officer.
20, thus.
Thus, at a minimum, defendant Kohberger must establish that the search warrant affiants knew the FBI specialist's identification was based on incorrect footage, yet intentionally or recklessly relied on it anyway to obtain warrants. There is no evidence to this end. Assuming the Ridge Road footage was in fact not of suspect vehicle 1, the affiants were not part of the FBI email chain, which allegedly evidences the use of the Ridge Road footage to make the identification. Further, there is no evidence law enforcement provided the Ridge Road footage to the FBI for identification purposes, knowing it was not of suspect vehicle 1. Consequently, a Frank's hearing is not warranted.
And I just want to say, only because we went through this so much, all this shows is, one, Anne is doing her job. But with that being said, we had to argue this so much that it is her job to be very tricky with her words, to poke holes, and to have it worded a certain way and everyone just ran with it all the time. Meanwhile, now listen, the judge has the information, and even though we don't get all of it, everything is still like very tight. The little bit we're getting, he's explaining, no. See, you worded it in a way where that's not the case. You positioned it in a way where that's not the case. And no, that's, it's not the case. And so that's not a dig at Anne. That's her job. But people were so convinced, and I'm not saying Kohberger is 100% guilty. I'm just saying people were so convinced. Oh, look at what she said here. Look what she said there. No shit. That's her job. But it doesn't mean that it's this setup.
Yeah, and I think we also have to remember that, hold on. Right, because the Frank's hearing is specifically going to be to, it has to do, with being able to do the search warrant. So the information in there is that probable cause, but I have a feeling that we may find out that some of the information may remain consistent in fact, and then other things we may find out develop more.
Yeah.
Because that's the way I'm looking at it. Like, she's looking at what was presented to them and also what was presented to the grand jury,
Yeah.
And that's where I think once we have all of the evidence that they're going to put forth, will be really telling.
For sure.
Okay, so C, defendant has not met his Frank's burden on issue 5, misleading timeline. Oh gosh, here we go. In issue 5, which applies to all warrants, defendant claims that law enforcement created a false narrative of their investigative timeline in Exhibit A, so as to make it appear that Kohberger was identified through their investigative efforts and not in fact through IGG. In other words, he argues that law enforcement, having already identified Kohberger through IGG, tailored their Exhibit A to support probable cause for an already identified suspect, not an unknown suspect. Kohberger provides 2 examples of what he contends are misleading timelines about his identification, but these examples fall far short of the Frank standard. First, Kohberger notes that in Payne Exhibit A, Detective Payne states that on November 29, 2022, officers from Washington State University, WSU, queried white Hyundai Elantras registered at the school and pulled up a 2015 white Hyundai Elantra with Pennsylvania plates that was registered to Kohberger. That same day, Detective Payne states another WSU officer was patrolling the area by Kohberger's apartment and located a 2015 Elantra with Washington plates. He ran the plate and it returned to Kohberger. Kohberger points out that Detective Payne was not even aware of the WSU officer's findings in this regard until December 20th, 2022, after Kohberger was already identified by IGG. However, he contends Payne Exhibit A makes it appear that Kohberger was identified in part through the WSU queries, which that is a theory a lot of us had. I had that too.
Yep. That was the first time I heard, also, aside from running the registries, that the WSU officer was patrolling the area by Kohberger's apartment and spotted by his eye the Elantra with Washington plates.
Mm-hmm. And I thought he had already changed, or maybe he was waiting for them to get in, because didn't he register in Washington, like right after,
Yeah.
within the week after the crime.
Mm-hmm.
Okay, so second, defendant takes issue. Which, sorry, go ahead.
No,
Did I
I
cut
was
you?
reading my comment.
Okay, sorry, I thought I cut you off. Second, Kohberger takes issue with Detective Payne's focus on suspect vehicle one's lack of front license plate. In Payne Exhibit A, he discussed his review of surveillance footage, noting a review of camera footage indicated that a white sedan, hereafter suspect vehicle one, was observed traveling westbound on Steiner Avenue at Idaho State Highway 95 in Moscow at approximately 3:28 a.m. On this video, it appeared suspect vehicle one was not displaying a front license plate. And then it lists the exhibit. Detective Payne later points out that Kohberger registered his 2015 White Elantra with Washington State on November 18, 2022. He noted that previously the vehicle was registered in Pennsylvania, which, unlike Idaho and Washington, does not require a front license plate to be displayed. Kohberger contends that although Exhibit A makes it appear that law enforcement was focused on the lack of a front license plate early on, it was not until after he was identified through IGG that it became an object of inquiry. In neither example has Kohberger established Detective Payne's investigation timeline to be misleading or false, much less intentionally or recklessly so. There can be no question that Kohberger was identified in part through the WSU officers' queries and through the suspect vehicle's lack of front license plate, as observed in surveillance videos from the night of the murders. The fact that law enforcement had additional DNA evidence tying the Kohberger to the crime does not render it improper for law enforcement to rely on independent evidence accomplishing the same. It would arguably be irresponsible for law enforcement to rely solely on DNA evidence without making any effort to corroborate it, particularly given the novelty of IgG. Kohberger has not established there is anything wrong with this approach. See United States versus Taylor, observing that requirement under Franks that search warrant affidavit be truthful and complete does not require that every fact recited therein be corrected or that every detail of investigation be provided. Indeed, what is important to probable cause is the totality of the evidence, once all gathered and examined in light of what that collection of evidence shows, not looking at it in isolation as each piece of evidence was separately gathered. That's what we've been saying.
Mm-hmm.
Moreover, had law enforcement indicated in Exhibit A that the WSU query and lack of a front license plate only came across its radar after Kohberger had been identified through IGD. Kohberger has not explained how this would have eroded probable cause. Indeed, as discussed below, including the IGG evidence, would have provided more, not less, probable cause, supporting the search warrants. Consequently, a Franks hearing is not warranted on this issue. And that's it on that part. I think this is going to get into the dogs and the rooms and stuff.
Mm-hmm. So E says defendant has not met his Frank's burden on issue 6, the dog barking. In this issue, Kohberger challenges omissions pertaining to the barking dog referenced in the Payne Exhibit A. It states that at 4:17 a.m., a security camera located at a nearby residence on King Road picked up, quote, distorted audio of what sounded like voices or a whimper, followed by a loud thug. A dog can also be heard barking numerous times starting at 4:17 a.m. The only other information in the Payne Exhibit A pertaining to a dog refers to the fact that Kaylee's dog Murphy was found in her bedroom by first responders. Kohberger contends that Detective Payne failed to include 3 allegedly important pieces of information pertaining to the dog. 1, that the dog heard on the security camera continued to bark for 30 minutes after the suspect left. 2, that Detective Payne conducted a test to determine that the dog was likely outside while barking. And 3, that Murphy was found without any blood on him, even though the bedroom doors were open where the descendants were found. According to Kohberger, this omitted information would have revealed that, quote, whoever was in the house brought the dog back inside after the suspect vehicle left. He further argues this information is material and exculpatory because it, quote, undermines the narrative and timeline that supports probable cause. However, Kohberger's argument assumes without proof that there were no doors left open in the home after the suspect left. This assumption is not only speculative, but contrary to evidence in his proffer that the sliding glass door to the residence, the same door towards which Dylan reportedly saw the suspect walk, was left open. Thus, if the dog heard barking was in fact Murphy, it could have well come back inside through the open door and gone into Kaylee's room on his own, where it evidently remained. There is simply no evidence to adopt Kohberger's speculation that someone brought Murphy inside after the suspect left the residence. Consequently, Kohberger has not shown that the failure of law enforcement to so speculate was a material and exculpatory omission that was intentionally or recklessly excluded. A Frank's hearing is not warranted on this issue. So, the police report indicating Murphy did not have blood on him, and Exhibit D15B is a screen capture of Officer Nunez's body camera when he arrived at the house, showing the Murphy lying on Kaylee's bed with no blood on him.
Oh, he was on her bed.
Yeah,
Oh my God, my heart breaks.
I know. The witness. Well, if he perceived police were on the way.
So
Okay.
this is assuming the doors were left open.
Which it would have been freezing.
Well, and it could be do you remember in the probable cause, did it describe the smell of blood?
No.
Because I mean, if you have the doors open, that could also be a reason why you wouldn't,
No. Because we went on and on and on and on and on about whether or not the doors were left open, hence why it wouldn't have been a strong odor of blood. But if the doors were left open, it argued, why wouldn't Dylan call? It would be freezing. Why wouldn't she leave her room? Remember?
Oh my gosh, you want to know something? Guess what? I have something I'll tell you, and this is relevant, and it has to do with the cold, okay? So last weekend, I'm in Texas, and I'm just gonna say this. My neighbors across the street, their front door was open, and it was 15 degrees out, Melissa. My husband was like, oh my gosh, what's wrong? Like, I could see through their back door. There's no cars out front, like not in their driveway. He called 911. The police show up. And they're like, do you know them? He's like, no, not really. Like there are a few people that live there. They're like roommates. They're like in and out all the time. And they're like, okay. So the police announce themselves. They walk in, and they ended up finding somebody that was asleep, and they had no idea why their door was open, why the police were there. He asked him, the cops relayed this back to my husband, and he was like, did you not feel the draft? It was cold, it's 50 degrees out. He's like, no, I didn't feel anything. We're under blankets. So I thought that was crazy, because I was like, how did you not feel that,
Yeah.
And why was your door left open? So I don't know. It's just odd.
That is strange.
It is. Oh, okay. I have so many questions.
It's a lot of questions.
So do you still think at this point that Kaylee was sleeping in Maddie's bed then?
Yeah, 100%.
But why would Murphy be left to walk around the house?
I don't think that's strange at all. Like, I don't even know if she intended to fall asleep. They were drinking, they were eating, they were calling Jack, like they were hanging out. She was there for the night. I don't think that's crazy that Murphy was most likely in her room right next door.
With the door open.
Yeah, why wouldn't the door be open?
I don't know. I guess if I just had other roommates, like I would think they would expect me to keep my dog put up.
No, not at all. He was a baby. There are photos with all of him. Who knows how he was trained? Hi, Rebecca. I don't find that odd at all.
I think there's more to it.
Maybe.
Okay. F, defendant has not met his Frank's burden on issue 7, cell phone data. 30, clip note 32, issue 7 applies to all warrants issued after December 23rd, 2022. So issue 7 challenges Exhibit A insofar as it discusses data from defendant's phone, referenced as the 8458 phone in Exhibit A, and conclusions drawn therefrom. He asserts that Exhibit A falsely implies Kohberger's location on the night of the murders based on improper speculation, misrepresentations, and omissions about 4 topics. 1, the geofence return. 2, the timing of the second AT&T warrant. 3, the time Kohberger's phone stopped reporting. And 4, the cell tower coverage area. So it says the cliff note says Kohberger included a subsection on the CSLI data indicating that it supports a finding that Kohberger traveled south from Pullman sometime after 2:42 a.m. This appears to be duplicative of the section regarding the time Kohberger's phone stopped reporting to the network. Okay. So it says Kohberger's proffer on each of these topics is insufficient to warrant a Frank's hearing. 1, the geofence return assertion was not a false or misleading statement. Kohberger first takes issue Detective Payne's assertions regarding the geofence return. In Payne Exhibit A, Detective Payne informs the magistrate that a query of the 8458 phone in these returns did not show the 8458 phone utilizing cellular tower resources in close proximity to the King Road residence between 3 a.m. and 5 a.m. He then states, based on my training experience and conversations with law enforcement officers that specialize in the utilization of cellular telephone records as a part of the investigations, individuals can either leave their cellular telephone at a different location before committing a crime or turn their cellular telephone off prior to going to a location to commit a crime. This is done by subjects in an effort to avoid alerting law enforcement that a cellular device associated with them was in a particular area where a crime is committed. I also know that on numerous occasions, subjects will surveil an area where they intend to commit a crime prior to the date of the crime, depending on the circumstances. This could be done a few days before or several months prior to the commission of a crime during these types of surveillance. It is possible that an individual would not leave their cellular telephone at a separate location or turn it off since they do not plan to commit the offense on that particular day. Kohberger contends that Detective Payne's claim that criminals will turn off or leave their cellular or their cell phone elsewhere before committing crimes is highly speculative and conclusory. He argues that this is just as likely the phone was not present in the area. Kohberger has not demonstrated the statement was deliberately or recklessly false. What Payne Exhibit A shows is that Detective Payne, based on his training experience, drew one conclusion about the lack of a return to the exclusion of other possibilities. While there certainly may be other reasons for the lack of a return, the mere fact that the affiant did not list every conceivable conclusion does not taint the validity of the affidavit. Further, Detective Payne's conclusion was expressly based on his training and experience in conversations with other experts, which further belies any suggestion that it was deliberately or recklessly false. The Frank's hearing is not warranted on the issue.
See, tricky use of wordings. I know. Okay, so 2, challenge to timing of the second AT&T warrant is conclusory. Defendant next challenges the 1-hour turnaround from when law enforcement received the return of the first AT&T warrant and submitted the application for the second AT&T warrant. According to Kohberger's expert Thomas Slavensky, it takes 1 to 2 days at a minimum to secure call detail records from AT&T and then convert, analyze, and peer review them. He surmises that the fact that Detective Payne was able to complete these tasks in 1 hour means that the FBI has already secured and analyzed the information and provided their analysis to Detective Payne who simply reported to the magistrate what he was told without telling the magistrate the truth about how the investigation truly unfolded. Franks does not contemplate such conclusory accusations. Mr. Slavinsky was not involved in the investigation, and his attempt to impute untoward conduct to law enforcement lacks any foundation. As Detective Payne testified at a prior hearing in this matter, he received the return from the first AT&T warrant and immediately turned the material over to the FBI agent Balance to begin deciphering it while Detective Payne started on the second search warrant application. While Kohberger may wish to cross-examine Detective Payne on the issue, it is not a basis for a Franks hearing. Further, even if the FBI had already secured the records prior to receiving the return on the first AT&T warrant, Kohberger has not shown how the inclusion of this information in Exhibit A would have negated probable cause. A Franks hearing is not warranted.
3, defendant has not shown the alleged misstatement regarding when Kohberger has not shown the alleged misstatement regarding when Kohberger's phone stopped reporting was intentionally false or exculpatory. Kohberger next asserts that Detective Payne misrepresented the time Kohberger's cell phone stopped reporting to the network to imply that Kohberger was traveling toward Moscow between 2:47 and 2:54 a.m. when he was not. AM memo, page 25 on this point. Kohberger relies foremost on the affidavit of his expert, Mr. Slavinsky, who states, affiant has found inaccurate information in Officer Payne's affidavit for search warrant and application for an order for a PIN registry or a trap and trace device, dated December 23rd, 2022. Payne makes a false statement in his affidavit. Payne states in his affidavit, it's a bait stamp, that at approximately 2:47 a.m., the 8458 phone stops reporting the network. This statement is erroneous. Payne has failed to advise the court of the following. 1, the 2:47 a.m. traffic is continuous 7-minute stream on multiple towers that ends at 2:54 a.m. Payne does not document this 7-minute traffic. Okay, so 2, Payne did not inform the magistrate about these handoffs, which would have clearly and directly shown him the fact that on November 13, 2022, from 2:47 to 2:54, Mr. Kohberger's device was not heading to Moscow as purported by Payne, but was indeed heading southbound from Pullman, Washington. The fact that Payne either disregarded or was not aware of the handoffs in direction of travel of Mr. Kohberger's device gives this affiant grave concern over the lack of training and experience Payne has in mobile forensics and the credibility of the affidavit. And then exhibits. The defendant's other cellular expert, Cy Ray, likewise contends he has reviewed multiple search warrant affidavits prepared by Detective Payne, and his statement that that Kohberger's cell phone stopped reporting to the network at 2:47 a.m. is blatantly false and not supported by the AT&T data. In addition to these two expert affidavits, Kohberger includes in his proffer the AT&T call detail records (CDRs) that purportedly reveal that the actual time the phone stopped reporting to the network was 2:54 a.m. As an initial matter, Kohberger has not provided the search warrant affidavit identified by Mr. Slavinsky with his proffer. The only search warrant affidavit authored by Detective Payne that Kohberger has provided with this proffer is Payne Exhibit A, which is dated December.
So no, they didn't even fucking provide. Okay, go ahead.
Yeah, I was just thinking that too. I was like, huh? Which is dated December 29, 2022, and accompanied an application for a warrant for Kohberger's arrest. And it says, see exhibit, the court cannot consider the effect the alleged misstatement would have on probable cause without the correct affidavit before it. Oh, man. However, the search warrant affidavit referenced by Mr. Slavinsky is otherwise part of the record in this case as to other motions, and the court will take judicial notice of it for purpose of deciding the issue. And so the issue for 34 says, see the affidavit of the search warrant. That's it. Okay. I thought it was something. The court does not find defendant's proffer deserving of a Franks hearing. First, Kohberger has not established the challenge statement is a misrepresentation. Detective Payne expressly qualified his statement by noting it was an approximation only, as he testified to it at an earlier hearing in this matter. Detective Payne is not an expert in deciphering CDRs. Thus, he provided the records to FBI Special Agent Balance to analyze and relied on Agent Balance's analysis in drafting the PIN register affidavit. That affidavit disclosed both Detective Payne's reliance on Agent Balance's analysis and Agent Balance's training and experience to the magistrate. To the extent the approximation was off, a 7-minute discrepancy, particularly one occurring more than 1 hour prior to the homicides, is not so far outside the approximate window as to render the statement false. Further, even if the statement could be characterized as false, Kohberger has not shown it to be intentionally or recklessly so. In fact, not even Mr. Slavinsky goes so far impute this mens rea to Detective Payne. Rather, he points out that Detective Payne either disregarded or was unaware of the handoff data that would have revealed the correct time the phone stopped reporting. Based on Detective Payne's self-described lack of expertise in analyzing CDRs, it is reasonable to infer the latter, which amounts to, at most, negligence. Further, Detective Payne relied on Agent Balance to decipher the CDRs, which he is entitled to do in executing probable cause affidavits. Finally, Kohberger has not shown Detective Payne's mistake in identifying the handoff data to be exculpatory. Mr. Slavinsky claims it was exculpatory because a correct interpretation of the data would show the device was not heading to Moscow as purported by Payne, but was indeed heading southbound from Pullman, Washington. There are two problems with this assertion. First, the PIN register affidavit represents that the device was traveling south at 2:47 a.m. when, according to Detective Payne, it last reported to wit on November 13, 2022 at approximately 2:42 a.m. The 8458 phone was utilizing cellular resources that provided coverage to 1630 Northeast Valley Road, apartment G201, Pullman, Washington, hereafter the Kohberger residence. At approximately 2:47 a.m., the 8458 phone utilized cellular resources that provided coverage southeast of the Kohberger residence, consistent with the 8458 phone leaving the Kohberger residence and traveling south through Pullman, Washington. PIN register affidavit exhibit. Thus, because the exculpatory information identified by Mr. Slavinsky appears to have been represented in the affidavit, the court is at a loss at how to correct statement of the time the phone stopped reporting to the network would affect probable cause. Second, even if the PIN register affidavit did misrepresent that Kohberger's cell phone was headed to Moscow between 2:47 and 2:54 as opposed to the southbound from Pullman, a correction would have no effect on probable cause. Traveling southbound from Pullman at 2:54 a.m. more than an hour prior to the homicides does not disprove that Kohberger could have driven to Moscow after 2:54 a.m., after his phone stopped reporting to the network. As the affidavit points out, footage from multiple videos obtained from the neighborhood around 1122 King Road showed several sightings of a vehicle matching the description of Kohberger's vehicle starting at 3:29 a.m. and ending at 4:20 a.m. Given the proximity of Pullman to Moscow, the fact that Kohberger may have been traveling southbound in Pullman at 2:54 a.m. does not exclude him as the potential driver of the suspect vehicle from a probable cause standpoint. Moreover, the strength of the other evidence described in the PIN register affidavit cannot be overlooked. The affidavit describes how CSLI data showed that Kohberger's cell phone left his apartment at approximately 2:45 a.m. and started traveling south before it ceased reporting to the network, approximately 90 minutes before the homicides occurred. The phone then started reporting to the network again 90 minutes after the homicide occurred, at which time it was traveling south on Highway 95, just south of Moscow, before looping back into Pullman via Highway 195. Consistent with this CSLI surveillance cameras from the Pullman area showed a white Hyundai Elantra consistent with Kohberger's vehicle returning to area of Kohberger's department at 5:25 a.m. As Detective Payne pointed out, individuals commonly turn off their phones prior to committing a crime um, to avoid alerting law enforcement of their presence near a crime scene. The obvious inference is that Kohberger turned off his cell phone to avoid detection until he was clear of the crime scene. In addition, the affidavit described footage from multiple surveillance videos that captured a vehicle consistent with Kohberger's makes 3 passes by 1122 King Road between 3:29 and 4:20 a.m., at which time it departed from the residence at a high rate of speed. On one surveillance camera, according to Detective Payne, the suspect vehicle did not appear to have a front license plate. He noted that Kohberger's vehicle had been registered in Pennsylvania at the time of the homicides, which does not require the front license plates be displayed. Finally, CSLI evidence shows that at approximately 9 a.m., November 13, 2022, a mere 3 and 1.5 hours after Kohberger's 3.5 hours, so 3.5 hours after Kohberger's return to his apartment, he again left his apartment and returned to Moscow, utilizing cellular resources that provided coverage to 1122 King Road from between approximately 9:12 a.m. and 9:21 a.m. before traveling back to the area of his apartment at 9:32 a.m. This is consistent with Kohberger returning to the scene of the crime. Detective Payne also noted that Kohberger's height, weight, and ethnicity were consistent with Dylan's description of the perpetrator. He informed the magistrate that Kohberger was a PhD student in criminology at Washington State University and had studied how technological data is used by law enforcement. The inference to be drawn from this information is that Kohberger knew, particularly from a technological perspective, how to cover his tracks. When the extent of this evidence recounted in the pen register affidavit is considered as a whole, it is evident to the court. That had Detective Payne stated Kohberger's cell phone was traveling southbound from Pullman when it stopped reporting to the network at 2:45 or 2:54 a.m. There was still enough probable cause linking Kohberger to the homicides to justify the issuance of the search warrant. Consequently, a Frank's hearing is not warranted on this issue.
All right.
And
go ahead.
I don't know about you, but I always go back to that one interview, and I know I have it saved like nearby. The one with Kaylee's dad's Steve, and he was talking about how like he was like touched their Wi-Fi.
Yeah.
I kind of wonder like if there's some collaboration into that, you know?
Might be. I'm not sure. We've always speculated about that and like where he was getting that from.
Mm-hmm.
But I can't, like, I don't know. I'm waiting for that because, and not to take
That's
it.
never left my mind, you know?
Yeah. Yeah. It's always kind of like, where did that come from?
Right.
Grand jury leak? No, wait. Did the grand jury happen at that point? Yeah.
Of what?
Yeah. No, I don't know. I really don't know. But they've said a lot too, like respectfully. And so I don't know.
Or are they asking, did Steve make that statement after the grand jury or
Yeah.
before?
Yeah, he
Oh,
did.
he made it before. He made it before. He made that statement early on. I'm pretty sure.
That Kohberger's he was close enough to touch the Wi-Fi? How? In the grand jury? We'll have to go back and look.
Yeah.
All right. So it says 4. Kohberger has not shown any omission regarding cell tower coverage area was reckless, intentional, or material. The final claim raised by Kohberger is that Detective Payne omitted important information about cell tower coverage in Moscow when he stated that the records for the 8458 phone show that the phone utilizing cellular resources that provide coverage to the area of 1122 King Road on at least 12 occasions prior to November 13th. So according to Mr. Slavensky, the two towers that provide AT&T service to King Road also provide coverage to all Moscow, including the area that Kohberger is known to shop. Thus, Kohberger claims that Detective Payne misled the magistrate about the location of Kohberger's cell phone on these 12 occasions. The accusation here is one of omission, specifically whether Detective Payne recklessly or intentionally withheld from the magistrate that the same towers providing service to King Road also provide coverage to all of Moscow. There is no direct evidence that Detective Payne intended to mislead the magistrate, nor can it reasonably be inferred given that Kohberger has not shown the omission to be material or exculpatory. While including the information may shed some doubt on whether Kohberger was actually in the vicinity of the King Road on these 12 occasions as opposed to some other nearby location, it does not disprove Detective Payne's statement or otherwise exculpate Kohberger. Given the breadth of exculpatory evidence included in Payne's Exhibit A, it is difficult to ascribe ill intent to this alleged omission. Further, and importantly, probable cause did not arise and fall on the evidence of Kohberger's 12 prior visits to Moscow. A Franks hearing is not warranted on the issue. G says defendant has not met his Franks burden on issue 9, footprint outside of Dylan's door. In issue 9, defendant challenges as false a statement made in Payne's Exhibit A about a footprint outside of Dylan's door. Detective Payne stated, during the process of the crime scene, investigators found a latent shoe print. The detected shoe print showed a diamond-shaped pattern similar to the pattern of a Vans-type shoe sole just outside the door of Dylan's bedroom, located on the second floor. This is consistent with Dylan's statement regarding the suspect's path of travel. Kohberger contends the last sentence is false, noting that the footprint is closer to her bedroom door than she reported the suspect to be. There are no other prints before or after it, and it is not positioned towards the sliding glass door, which is where Dylan said the suspect walked after passing her by. Shows the footprint at the threshold of Dylan's bedroom door. Kohberger further claims it is an intentional or reckless statement because its only purpose was to corroborate Dylan's unreliable statements. There is nothing false or misleading about Detective Payne's statement. The shoe print was consistent with Dylan's account. She told law enforcement she saw the defendant walked past her bedroom door after she opened it for a third time. Quote, and then I opened the door again and the guy is right there, end quote. Quote, I think he was walking past my door and saw me. I would say about 3 feet away from her. Saw her, Shay. Dylan's bedroom door is immediately at the landing of the base of the stairs leading to the upstairs bedroom. The shoe print was therefore reasonably within the suspect's path of travel as described by Dylan. The fact the footprint was located only in one spot and there were not others before and after, it does not make Detective Payne's statement false about the path of travel. Consequently, Kohberger has not shown Detective Payne's statement was false or otherwise misleading. Additionally, Kohberger has not established that Dylan's interview statements were wholly unreliable, as discussed supra, and that there were otherwise a need to bolster her credibility in the magistrate's eyes through false corroborations. Consequently, even if the shoe print was not totally consistent with Dylan's account, Kohberger has not demonstrated that the statement was made deliberately or recklessly. Moreover, Kohberger has not articulated how excision of the statement would have any bearing on probable cause. In fact, it would not. A Franks hearing is not warranted on the issue.
Oh, wow.
Very interesting.
H, defendant has not met his Frank's burden on issue 11, the grand jury subpoenas. Okay, sorry, 1 second.
Good night, Justin.
All right, I know we're almost done. Sorry. Okay, so issue 11. Okay, yeah. Well, the defendant has not met his Frank's burden on issue 11, grand jury subpoenas. Issue 11 faults law enforcement for omitting information in Exhibit A supporting the search warrant for Amazon records, which was issued May 8, 2023. Specifically, he asserts that the affiant, Detective Mowry, requested the warrant in reliance on federal grand jury subpoenas issued by the FBI to Amazon, but did not tell the magistrate information about the timing and scope of information obtained and relied upon. Amazon memo, page 31, defendant further states he is unable to ascertain whether the omission was material and exculpatory because the grand jury subpoenas have not been disclosed. Kohberger has not established that this issue is the proper subject of a Frank's motion. He has not provided the search warrant affidavit at issue, has not identified any false statement, and the only omission he challenges is that Detective Mowry did not disclose unidentified particulars about the timing and scope of information obtained from the grand jury subpoenas. He admittedly cannot show this omission was material and exculpatory, and therefore cannot establish that probable cause would have been affected had the omitted information been included. What this challenge appears to be is an attempt to use Franks as a means for discovery, which is not its purpose. Consequently, a Franks hearing is not warranted.
Very interesting.
I think, I mean, because the fact that they want Amazon out, to me, that tells me like that they, because, you know, you sign up like on a site, you just like click through all the things you agree, but like they're paying attention to everything you click and look at. But also, guys, think about this. What if they noticed like he had purchased something of the sort that was similar? Anybody can have a knife. But the question is, it's like, hey, Bryan, where is that thing you just bought? Where is it? Because it's the lack of stuff that matters too. And that's what I think some people just forget. It's not about also what you can show, it's what you can't show.
Like pillowcases. No, but really. The lack of the pillowcases.
The shower curtain. The shower curtain.
Exactly. Oh, okay. Defendant Kohberger has not met his Frank's burden on issue 12, which is the lack of connection between Kohberger and the victims. In issue 12, Kohberger challenges law enforcement's omission in their Exhibit A's of the fact that their investigation failed to reveal any connection between Kohberger and the victims. Kohberger claims this information was material and exculpatory because it sheds doubt on law enforcement's theory that Kohberger was, quote, the right person. However, Kohberger has not established the lack of connection was a fact conclusively known to law enforcement at the time the search warrant applications were submitted.
Okay. Stop. Pause there and go to the bottom. Let's read the bottom first.
So the Frank's law,
40.
It disclosed that evidence does not exist or has not been found. This is not a realistic burden, particularly given that search warrant affidavits are typically executed under rapidly unfolding circumstances. Indeed, there is no requirement under Frank's that law enforcement disclose every detail of an investigation or describe every wrong turn or dead end they pursued. Certainly, then, there is no requirements to disclose a lack of evidence, particularly when the obvious inference to be drawn from the absence of any mention of such evidence is that it does not exist or has not been located. So, thus, he cannot establish it was intentionally or recklessly omitted. Moreover, this omission was not material or exculpatory. Had law enforcement found a connection between Kohberger and the victims prior to applying for search warrants, it is reasonable to assume the connection would have been disclosed in the search warrant affidavits. The fact it was not disclosed necessarily allowed the magistrate to reasonably infer that no connection had yet been found. Yet she still found probable cause to authorize the search warrants, as was reasonable to do. Consequently, Kohberger has not carried his burden under Frank's on this issue. Jay, I'm excited.
I know. That's why I want to go back over to that Shadow Dragon stuff. I still have it. That social media report they did. Okay. So the defendant has not met. So defendant has not met his Frank's burden on issue 13. Lack of victim DNA in apartment and vehicle. Yay. Sorry. Similarly, defendant challenges law enforcement's omission in the Exhibit A's of the fact that lab testing performed by the Idaho State Police did not reveal the victim's DNA in Kohberger's vehicle or his apartment. Exhibit D25, A through C. Kohberger contends the lack of DNA is devastating to law enforcement's theory of the case and was intentionally or recklessly omitted. However, As with the prior issue, Kohberger has not established when law enforcement knew of the lack of the victim DNA in the defendant's vehicle and apartment. The three ISP lab reports relied upon by Kohberger were issued on March 2nd, March 8th, and May 23rd, 2023, respectively. Thus, it cannot be said that law enforcement knew of the lack of DNA until the last report was issued. Kohberger was provided or identified any search warrant affidavits he was not provided or identified any search warrant affidavits submitted after May 23rd, 2023, much less explained why the lack of DNA was material to probable cause for those warrants. In his reply, Kohberger claims that the actual testing for DNA was performed by ISP long before the three lab reports were issued. He asserts he has reason to believe that the results of the testing were verbally transmitted to law enforcement at that time. However, the evidence submitted by Kohberger does not support this assertion. Just seen it. Okay. First defendant submits the ISP lab notes from lab report 28. Kohberger submits the ISP lab notes for lab report 28 and claims that the testing was done on February 13, 2023, 3 weeks before the report was actually issued. A closer review of those lab notes reveals that testing of the various items at issue in lab report 28 took place between February 13, 2023 and February 24, 2023. The final report was issued 4 working days after the last test. Thus, this evidence does not show that law enforcement knew well before lab report 28 was issued that there was no victim DNA on the tested items. This is at best Kohberger's speculation. Kohberger also submits lab reports from a hair and fiber analysis performed by the FBI lab. The first lab report, dated January 27, 2023, revealed that hair and fibers collected from the crime scene were not consistent with Kohberger's hair sample. The second lab report, dated February 28, 2023, revealed that hair and fiber samples collected from Kohberger's vehicle and apartment were not consistent with the victim's hair samples. Again, this evidence does not support Kohberger's assertion that law enforcement knew of the lack of victim DNA in his vehicle and apartment as of January 5th, 2023. At best, it can be said that law enforcement was aware as of February 28, 2023, that the FBI's testing did not reveal the victim's hair or fibers in Kohberger's apartment or vehicle, but it is evident from the various lab reports that law enforcement's investigation with regard to DNA was still continuing. Therefore, there was no basis for law enforcement to definitively aver that there was an absence of victim DNA in the vehicle and apartment until the final reports were issued. In other words, Kohberger has not demonstrated an omission, much less that it was intentional or reckless. Further, Kohberger has not demonstrated how including this omission would have affected the magistrate's finding of probable cause. He contends that it would affect all warrants issued January 5th, 2023 and beyond, but he's not provided any search warrant affidavits from the time period of the court's consideration. However, based on the Payne Exhibit A that is included in Kohberger's proffer, the probable cause as of December 29, 2022 included, among other things, that the DNA profile obtained from the trash pull of the Kohberger family's trash was determined to be from the biological father of the source of the DNA left on the knife sheath at the crime scene. Given this evidence, no reasonable magistrate would conclude that the lack of victim DNA in Kohberger's vehicle and or apartment weeks after the crime would negate probable cause. Thus, Frank's hearing is not warranted on this issue.
Okay. Defendant has not established the Frank's elements by a preponderance on issue 8, defendant's identification by IGG. Defendant does not identify what search warrants this issue applies to, but presumably it includes all warrants issued after defendant was identified through IGG as a possible subject. And we have 4 pages left, guys. I know it's a lot, but it's also really interesting.
Yeah, I know we wanted to like push through this because there's so much
Yeah.
other stuff.
Oh, yeah. In issue 8, Kohberger challenges law enforcement's omission in Exhibit A that Kohberger was identified through an allegedly unconstitutional use of IgG. He contends law enforcement should have disclosed in Exhibit A that 1, the methods used by Autism Labs to conduct the IgG testing allegedly did not meet minimum standards. 2, that the FBI failed to document its own IgG search using Autism's data. 3, that the FBI manipulated Autism's data to create a much larger DNA profile. And 4, that the FBI violated its own policy and that the commercial IgG databases it used when it uploaded the DNA profile to databases restricting law enforcement use. Kohberger contends these omissions from Exhibit A were purposeful. He also argues the omissions were material and exculpatory because they would have undermined probable cause by exposing law enforcement's false narrative of the investigation. Just pause real quick. Do you know how many times when that damn exculpatory evidence came up, how far out people went with the theories, but look how many things they are throwing under exculpatory evidence that are not exculpatory evidence.
Mm-hmm.
So, as mentioned, the court permitted a full Franks hearing on this issue. The court's findings of fact on the evidence and testimony presented and its conclusions of law are fully set forth in its memorandum decision and order on defendant's motion to suppress, re. genetic information, filed contemporarily herewith and incorporated herein. As the court determined in that order, law enforcement's use of IgG to identify Kohberger as potential suspect was not unconstitutional. The court found that regardless of whether the FBI arguably contravened its own policy and contravened that of MyHeritage and GED Match when it uploaded the DNA profile to their databases, it was not of constitutional importance. Moreover, Kohberger has not established that the search warrant affiants knew when submitting their respective Exhibit A's that the FBI or Autism did anything untoward with regard to their IgG searches. Detective Payne was the only person who had submitted a search warrant affidavit from whom Kohberger elicited testimony at the hearing with regard to IgG. Detective Payne testified that he knew the FBI was handling the IgG search after Autism Labs ceased work, but said his communication with the FBI about the issue was sparse and limited to check-ins to ensure the IgG search was continuing. He testified on December 19, 2022, the FBI provided him only with Kohberger's name and instructed that it was to be considered solely a tip. At some point after Kohberger was identified through IgG, the FBI walked Detective Payne through the details of the family tree it had developed from its search, but that was all. Further, he testified to having no familiarity about the IgG databases or rules that applied to them. Given the lack of evidence, Detective Payne knew or even had reason to know that Autism or the FBI did anything unconstitutional in their IgG searches, Kohberger cannot establish any omission in this regard from Exhibit A was intentional or reckless. Even assuming Detective Payne had been privy to the methods in which Autism and the FBI conducted the IgG search, Franks does not require law enforcement to divulge every detail of their investigation and describe every lead followed or rock unearthed for evidence. So probable cause affidavits are neither designed nor intended to be an opportunity for the reviewing magistrate to grade the police work on the case by requiring law enforcement to show every step that led to the evidence relied upon. As observed by one circuit court, there is no legal requirement that a police officer recite every fact that he knows in a search warrant affidavit, so long as what he does say is sufficient to support a judicial officer's finding of probable cause. So, an affiant must be more than wholly conclusory, but it need only provide the magistrate with a substantial basis for concluding that probable cause exists. It need not present all the relevant information known to the police at the time. In other words, the Fourth Amendment does not set forth some general particularity requirement. It specifies only two matters that must be particularly described in the warrant: the place to be searched and the persons or things to be seized. Likewise, there is no requirement that police include evidence as a straw man simply so that evidence can then later be attacked. The focus of an application for a search warrant is whether, based on the evidence that is presented, there is probable cause that evidence will be found in a particular place, not whether an evidence gathering technique used was potentially unconstitutional. While this may be fodder for a later motion to suppress, it is not a basis for Frank's challenge. Frank's in cases of omission asks simply whether the affiant left out evidence, which, if known, would negate the inculpatory effect of the existing evidence and leave an unsurmountable deficit in proof of probable cause. Kohberger has not established that omitting Kohberger's identification through IgG evidence or the means in which IgG was performed had this effect. Indeed, had the IgG information been included, even with the problems complained of by Kohberger, its only effect would have been to add to the probable cause, not detract from it. Consequently, relief under Frank's is not warranted. Conclusion: based on the foregoing, Kohberger's motion for Frank's hearing is denied. Wow.
Yeah, I mean, and I mean, there's still going to be a chance they're going to go through with motions of limine and suppressing,
hell yeah.
because there's going to be stuff that that may not be permissible as evidence into the hearing, or into the actual trial.
Yeah, guys. So we have and this is what we were talking about earlier, the state's motion in limine, the neuropsychological and psychiatric evidence. And
it's at the very, I think it's the case summary that had the list of other stuff.
Yeah.
Do you want to open that? Because that is actually, it's at the top. That's what's going to be coming that we can't see. No, sorry. I usually start there and then I go down. I'm like, what do you got? Let me see. I gotta compare them. Oh, there it is. And then you'll just want to scroll down to the last 3 pages or so. It'll be a 70-page document that'll pop up. This is all the stuff that they have on record, guys, that we're just scrolling through.
Right here.
Mm-hmm.
So the stipulated motion to file Kohberger's exhibit in support of their motion to strike death penalty, RE, autism spectrum disorder, under seal.
Yes. And then there's and then there's more stuff even above it that's coming that's interesting too. I think I don't know, where is it at? Sorry. So this hasn't posted yet to the site. So that's kind of what we'll see. A lot of people, if you see them posting oh, this is coming, it's just not on the docket yet. It'll hit the case summary first.
Mm-hmm.
So
that was a lot.
Can you scroll up just a little bit? I want to see what else is on there. Okay, that's the death penalty challenge. Keep going. Keep going.
Yeah, I was reading when I was scrolling.
Oh, sorry. So yeah, the motions of limine, these are the ones that are going to be interesting. That'll come out. Bushy eyebrows. I think that's the one that Scarlett pointed out.
Yeah.
Yeah. So even some of the stuff that they didn't get on the Franks hearing, they're going to try to attack it from the standpoint of motions of limine and suppressions.
Excluding Amazon click activity evidence.
Yeah.
Using the term psychopath versus sociopath.
Make and model of the suspect vehicle.
Amazon click activity.
Wait, what is this?
Witness identification by bushy eyebrows.
Yes. What is that one down there? It says, can you scroll down just a little bit? Motion 10? Improper expert opinion testimony. Okay.
Middleman.
Limine.
They were middleman.
Middleman?
Oh, sorry, middleman.
Oh, middleman. Okay. I thought the
fake undisclosed expert testimony.
Inflammatory evidence. Yeah, kind of interesting.
Text messages and testimony.
Mhm.
Improper death penalty comments. Is that towards Goncalves's family? So, on anyone who doesn't know, the Goncalves family war. You want to explain it?
Oh, yeah, I think Kaylee's aunt, like she was wearing like a
Pro
shirt
death
that's,
penalty.
yeah, pro death penalty shirt, and they are very pro death penalty. And I don't know what the opinions are of other families, but they may not all agree. I don't know. A lot of people had a lot to say about it because they are very vocal, but it's their right to be. This is their baby,
Well, the point is, though, are they going to try to get the family to not be able to attend or something? Like,
They
what are you
can't do
saying?
that. They can't do that.
It's interesting that
No.
it's filed. I guess we'll see. Oh man, that was a lot. My brain has to like absorb everything, and I'm gonna have to kind of go back over that and like. But yeah, I think we should probably go back and I don't know what's gonna come out from now until our next live. But either way, I think we should go over parts of that hearing.
Okay, yeah. You just let me know whenever, girl.
Oh my gosh.
Thank you for
And
having
yes,
me.
yeah, no, thank you. I'm just like my brain. I'm gonna be vacuuming up my thoughts all night for real. Like I have a lot to think about.
There's so many I just well, I have like a custom feed I made in my Reddit, so I have like a bunch of like Idaho subreddits like grouped together that I can see everything. And now kind of after it, I've been waiting and trying to hold off a little bit of going in there and seeing other people's thoughts because I like to hear what other people think. It
Oh
might not
hell yeah!
Yeah, it might not change like my feelings on something or my perception, but
It's always
more
good to hear
brains.
all different thoughts, and even sometimes, even if what someone else is saying you don't necessarily agree with, it could get you in a line of thinking of something else that you may not have thought of before.
Truth shot.
Oh gosh. Yeah, Marcus, wild ride. Oh
I
god,
know.
truth. Oh wow. Well, we'll go through whatever's comes out from now until the next live in a few days whenever we do it. But I also want to go through that hearing and listen to some major points of it. It's really not that long, but I know with commentary and stuff, it gets long. So we know what the good part. Most of it was very interesting, actually. Not even to say like it wasn't like long and drawn out. It was very interesting, the whole thing.
Yeah, and I actually like want to like go back and look at the social media report stuff that we had
Yeah.
too.
Yeah.
But but thank you for having me. I'm gonna
Yes.
jump
Thank you
down so
for
I can say
coming.
goodbyes.
Yes,
Thanks.
and thank you everyone in the chat. Harlot, you're the bomb.com. Thank you for holding it down in there. But I hope you all have a wonderful night. I know that we do the new photo drop and Patreon tomorrow night for the Wade stuff. So I'll see you guys then. But hit the thumbs up if you all already haven't. I hope you all have a wonderful night. And I'm going to be pondering my thoughts all night long. So I'll talk to you guys later.